Any mention?
My lord, item number 5, that order we are challenging of the learned single judge, my lord, where now EC is supposed to take a decision. Now the office is reopened, and probably in 2 or 3 weeks they will take a decision. They will take a call, my lord, on the representation that he has filed. So if it can come after 4 weeks, my lord, then we'll be able to know, my lord, whether they will reinstate or will contest the case, my lord.
4 weeks will be too low, I think.
Because, my lord, everything is hodgepodge now, my lord, in the district council. We need some time, my lord. All the MDCs has to be there, my lord, to take a call on this.
Okay.
3 weeks, my lord.
Item number 5, my lord. Item number 5.
Just before Christmas.
Before Christmas, yes, my lord.
After
It
3
may
weeks,
be very
my lord.
happy Christmas for him.
No, because since they are saying that they actively consider on the last occasion also.
Okay, yes, since it is open, yes, on the prayer, Mr. SD, Learned Standing Counsel for the respondents.
No, I'm for the appellant, my lord.
Oh, for the appellant,
Appellant.
sorry. Respondents Counsel, Mr. Counsel, let the matter clear after 4 weeks, yes.
My lord, high level, yes, my lord.
Give them time, what's the point of it? As we listed, yes.
Item number 1.
VP's Lordship. Lordship, this matter is being led by the Senior Government Advocate, Ms. N.G. Shila, Lordship. If this matter can be taken up at the end of the board, Lordship.
After 5 minutes, we will reach the end of the board.
Lordship.
Yes, what's the matter about? Who's appearing for the petitioner? Yes,
Contempt.
you, Mr. Please, you're muted. Unmute. Yes.
Please, Lordship.
Yes.
Lordship, this present petition is filed by the petitioner with the gracious and humble prayer for release of the amount of refund amounting to 10 crore and 98 lakhs since 2021. Lordship, my case was scrutinized by the respondent number 4 and allow me the excess amount 11.114 crore. And after that, I applied for the refund, annexure B.
Which page? Which page is that?
My case.
Where is the application for refund?
Refund 74 page, Lordship. 74 page.
Yes.
At the bottom.
Yes. So the excess was determined. Yes.
Yes, Lordship. After that, I applied for the refund. Then respondent number 3 has taken my case in the revision and
Yes.
reduced my refund to the extent of the 10.98 crore. Lordship, respondent number 3 and 4 forward the matter before the Joint Commissioner D1, D, annexure
Yes.
D. Since 1 year, they have not released my refund along with the interest.
Okay, at this stage, we'll issue notice who's appearing for the. Yes. Here, Mr.
Dr. Malkia.
Dr. Malkia Singh, Senior Counsel with so and so. Issue notice. MS N.G. Shila, Learned Senior Government Advocate, is present and accept on behalf of all the respondents.
All the respondents, Lordship.
All respondents, no further notice required. Just after 3 weeks for affidavit instruction. Yes.
Much obliged, Lordship.
Let them file application. We'll see.
Please, Lordship. Oblige, Lordship.
Yes.
Item number 2.
Next.
Please, Your Lordship. Lordship, an advance copy has already been served to my senior, my lord. We'll be filing the court today, my lord. My lord, we have just received it.
Yes, Mr. Jain General submits that the affidavit on behalf of the state or union on behalf of respondents number.
All the state respondents, my lord.
Not one, my lord. One was a formal response.
Union of India. We have respondent number
2. Sorry. Can you bear me just 2 and 3, my lord. Sorry.
2 and 3 will be filed, of course, the day. Just after 2 weeks for the joint venue.
My lord, there was an interim, it may continue.
Interim order shall continue until next day.
Deeply obliged.
Item number 3. Item number 3.
It please your lordships. I'm praying for some more time, lordship, to file our affidavit.
When was this matter filed? September.
Lordship. Yes, Your Lordship.
Yes, as prayed, further 3 weeks time is allowed to the respondents to file affidavit. Just thereafter also.
Highly obliged.
4.
3 and 4 is connected.
4 same order. Madam.
Yes. Any mention?
Lord, I beg to mention item 30. Lord, this is that rubber processing unit. Yesterday I was having a word with my learned friend and we discussed that maybe this matter can be resolved. So kindly, Lord, if your lordships defer it for 2 weeks, we'll try and...
The request
objection,
of
madam.
council of punch this matter for 2 weeks.
Deeply, Lord.
Wait, please, Your Lordship. Lordship, I beg to mention item number 20.
Number
20, Your Lordship.
20.
Yes, Your Lordship.
20 is in the order column.
Hearing, Your Lordship.
Hearing not 20. 20 is not hearing. Hearing starts at 22.
I think she meant 22, Your Lordship.
Which one? You don't have the list with you.
You see this. This is the list, no? 22.
What is this? You don't have the list you're
22, Your
mentioning.
Lordship. 22.
Then, no adjournment, so that you are mistaken. You ready with the matter?
No, Your Lordship.
Why do you adjourn this matter
I
again and
don't know,
again?
Your Lordship, because
Where's the senior?
I have also shared the list of books with them.
Lordship, we need some more time to go through the list, Your Lordship.
To go through?
Through the list of
On the last
judgments.
occasion also, Your Lordship, the same plea had been taken.
Part of matter, where's Mr. D or Mr. Deb? Just sending this, sending her just to face the barrage always. How many months you put in practice?
8 months, Your Lordship.
8 months. Okay. After you complete 1 year, you'll start arguing matters. Okay. Yes. After 2 weeks. Yes.
Obliged, Your Lordship.
Lordship, I beg to mention item 26.
26.
Yes, Your Lordship.
This is who's for the petitioner? Sincon.
26 is different matter, Your Lordship.
This you do one thing. You just verify. Yes. Any other mention? Let's call up the cases.
31, Your Lordship.
Yes.
Lordship, and for the respondent, right?
Where?
31, Your Lordship.
31.
No more mention. You mentioned another matter. You just be you be sure what I can call up the list. Mention the matters called out.
Supplementary list item number 1.
Yes, Mr. P.D. Sharma.
Yes, please, Lordship. Here the petitioner is the wife of the deceased employee, Lordship. The deceased employee, he was initially appointed on the 1980, Your Lordship. 1980.
80?
Yeah, 1980 he was appointed. There is
When he retired?
Yes, he died where he was in hardness, Your Lordship.
When?
He died on 26 September 2016. Now, Your Lordship, there is that for regularization and pay for the benefit of service. Now that there is a provision.
You never regularized for this entire service?
No, not Lordship.
From 1980?
Yes, Lordship.
1988.
1988. Till now have not been regularized. There is a notification, Your Lordship, where it says that the for regularizing that at least the minimum qualifying service is 5 years. There is a notification on 3rd August 2022, Your Lordship. We have annexes also. As per this one, they are supposed to regularize it.
Which department is this?
This is the education department, my lord.
I thought Mr. P.D. Sharma issued notice. Who's accepting notice?
Yes, I am, my lord. I'll tell you who I am.
So-and-so. Present acceptance of all the respondents. No further is required just after 2 weeks.
Lordship.
Instructions are happy with this.
You put
Item number 2.
Much obliged, Lordship.
What instructions?
Lordship, wait, please, Your Lordship. I have limited instructions, Lordship, that the account was frozen, my lord, on the basis of some of a compliant report, Lordship. So I pray that necessary orders may be passed here, Lordship.
The thing is that you see what has happened here. Why this court is number one is that there was an amount sought to be transferred to her account. Then she informed the bank that I don't know she got a message. I deny it. I don't know this thing. Don't accept this deposit. But even then, that deposit didn't come to your bank, correct?
No,
They didn't
no,
deposit
no.
and still they froze your account.
Yes, my lord. That's Lordship, this was done by the concerned police at Bangalore, Lordship. It was not done over here. So even from the concerned police authorities over here, they said that the petitioner has to contact the police in Bangalore, Lordship. So,
My lord, I am not aware who has done all these things and why will I do all
let
that?
necessary orders be passed, my lord, unless my senior is...
Mr. Shulai, what instructions you gave yesterday? Let's see.
Lordship, yesterday, Lordship, I have given one.
But instructions have changed today.
No, it's same, your Lordship.
You've given her a copy.
My lord, I have not got a copy and yesterday also I advised that to the court that I did not get any
No,
copy.
this copy he gave you or not?
No, no.
He did not give you a copy.
No.
So that's the instruction that it was from
Limited instructions, Lordship.
That is
You
the
can't orders.
Lordship.
Lordship, yes.
Yes.
Highly obliged, my lord.
Item number 3.
Please, Lordship, this is for clarification, your Lordship. This is the voluminous document where those document they have.
Why are you showing it, giving it to the court?
Lordship, I may be allowed to file the additional rapid because Lordship that these are the private respondent who has been marked as where they have mentioned that GT and invalidation.
I'm not repeat. This will not repeat what I said yesterday. Unless you have pointed allegations where it is supported by, material.
Yes.
To support your allegations, this court will dismiss this case now.
Lordship, this is the document where it is mentioned.
We'll dismiss it. This petition has no pleadings, has no materials. There's a vague thing that I have a PAN card, I don't have a PAN card. What does it mean?
Lordship, that's why I'm saying, of course, I did not include in that person. I should have included it.
Yes.
Lordship, I may be just permitted to withdraw, then maybe I given the liberty, so I will file a press.
Withdrawn, I am no.
Yes.
Mr. P.T. Sama, please submit instructions. You will not withdraw in the application, will liberty to file a fresh.
Lordship.
So advice.
Lordship.
Not objected to by another EAG. It stands closed on withdrawal, however, liberty has claimed.
Yes, Lordship.
It has to be complete. How?
Yes, Lordship. I'm sorry, Lordship. Much obliged, Lordship.
Please, Your Lordship. Your Lordship, we have filed this review petition along with the condonation of delay. There is a delay of...
What is the error?
The petitioner herein, Your Lordship, seeks to review the judgment and order dated 18/07/2025, Your Lordship.
Yes, what is the error in the judgment? See, review jurisdiction is very limited. So there has to be some error which will come within the, where, that was not to your knowledge, some new fact has come out which has which was there and not brought to notice of the court. You know what are the guidance for jurisdiction, correct?
Sorry, Your Lordship. As the connecting counsel is on legs, Your Lordship.
Who?
Mr. P. Robin.
Yes, Mr. Harun. What is the error? They've said there.
Lordship, I can take your Lordship to the grounds at page number 6. Lordship, that the grounds are not sufficient for review, Lordship. As per my limited understanding of. Lordship, ground number 1 is.
You engaged in the matter. Who was the early counsel who appeared in this matter?
Mr. K. Carlingdon, Your Lordship.
So he's not there anymore.
Mr. L's aim was conducting Lordship.
File appeal, you're not happy with the order. Where's Mr. Yubin?
It's on leg, Your Lordship, before division bench. Your Lordship, let the matter be called up after some time.
Take it up tomorrow. Okay, post it next week, Monday.
Will be obliged, Your Lordship.
Monday's holiday. Post it on Tuesday. Post it on Thursdays.
Thursday.
Item number 5.
Yesterday's matter. EG is supposed to appear in this matter.
Where's EG?
May please, Your Lordship. Lordship may have the matter that in for Lordship. The learned Advocate General is on next before Honorable Division Bench, Lordship.
What to do then?
May I have them the end of the board,
Will
Lordship.
will be, held to ransom by the unavailability of counsel.
My apologies, Lordship.
Then?
Circumstances, Lordship.
You are there.
My apologies.
What to do?
Well, they can file an affidavit in the meantime.
You file affidavit.
Lordship, may I have at the end of the board, Lordship.
What submissions does the Advocate General want to make? Has he instructed you?
Lordship,
Are they so earth-shattering that it'll change the whole dimension of the case? Then?
Lordship, just if this matter can be taken up there with board, Lordship.
Okay, after some time.
Much obliged.
5 and 6.
Daily list item number 1.
Anyway, it will come. What is this?
Lordship, in one I'm praying for some time, Lordship. Just
So there's a you objecting to the condemnation application?
it's already condoned, Lordship.
Delays in control.
Condone.
Just
Pray for time for objection.
I'll just take instructions, Lordship. In 2 weeks' time.
Tell Mr. Emilpur PS funds allowed 2 weeks time to obtain instructions. You have the respondent. No?
1 and 2. Both.
1 and 2.
Obliged.
Item number 2.
1 and 2.
3.
No, this matter was fixed for evidence.
We are ready, Your Lordship.
Almost the entirety of the witnesses have been covered in this matter. There is only one witness which is remaining, who is the returned candidate. Because we are.
No, where's the lawyer, right?
Yes, sir.
Who's the lawyer? Who's the?
I'll just call Your Lordship.
No, I mean we can't take it up now.
No, I'm not saying. There is another point, Mulot. As far as the returned candidate, we do not wish to lead the evidence of the returned candidate because he has nothing to demonstrate as far as Section 81 is concerned. So, Mulot, today we have moved an application. We are in the process of filing. We are moving an application for withdrawal of his name on the from the list of witnesses. So,
you don't wish to examine return candidate, so let it be. That's,
Sir, since they are dropping down, we have no issue.
you can't have an issue also. Who's the lawyer? Suppose who's the last witness you have?
the last witness, Milords, was Mr. Karnabi, the notary public. So
he has not tendered the evidence, is it?
that is done. That is
already completed.
No more witnesses, Milords, after this.
Yes, he's.
Then where's the application?
Milords, I am requesting if the matter can be taken up at the end of the board, the application would be already.
So then we'll close the evidence.
Yes.
Yes.
Then we'll fix one more short date for hearing on
Yes.
the
Yes.
materials, and then we will.
Yes, Milords. Yes.
It was good, only. Yes.
Yes. Obliged.
After some time.
Yes.
Item number 4.
The list. Here.
What's the name of the arbitrator?
My lord, here what happened, my lord? The panel of 18 arbitrators that was published by Ministry of Defence.
That was lapsed.
That is lapsed, my lord. So, my lord, now the
Then
situation.
go appoint arbitrator.
So, my lord, I was suggesting Chief Justice Rafiq can be appointed. In fact, I spoke to him. He's agreeable to that. My lord.
He's so
Because
far away.
No, they are from Ahmedabad, my lord.
It's a logistical problem because I believe Mr. Justice Rafiq, he's based in Jaipur, my lord. So leaving that aside for a moment, if I'm allowed to point out humbly, my lord.
We'll give it to Justice Banerjee. He finishes up in 2 hearings. One hearing.
That could be
Justice Banerjee, we're fine with that.
Lordship, if I can humbly place for Lordship's consideration, the list apparently has expired sometime in July, my lord. The section 21 which we had invoked was long back in November last year, my lord. So it is only because of the inaction of the respondents that the list has expired. But not to stress too much on that. The fact is that between the same parties, there was a section 11 petition not too long back in Bombay High Court, my lord, between today's petitioner and the union.
Different contract.
Different contract agreement, but the same GCC, same arbitration clause, my lord. This was after the list had expired. In that matter, my lord, union had no objection to appointment from that lapsed list, my lord. Appointment of
why they insist on Arvind and Saurabh Mathur? But my lord, my instruction is not to agree to the either Justice Rafiq or Justice Banerjee, my lord.
We'll pass orders.
So in that case, if Lordship allows, just a few days time for us also to maybe come back with a suggestion of our own in terms of...
See, when you can't reach, that's why Section 11 applications come to the court, for the court to make a decision.
Absolutely,
That's it.
absolutely. Bow down to that.
We've given enough latitude and...
No, bow down to that, my lord. Bow down to that, my lord. Just 2 days time, my lord. Just for us to come back with one or two names, my lord. Just 2 days time.
Well, but it's for the court to decide, man.
Absolutely. So they've given the suggestions.
We're not giving any breathing space. We take 2 days. It is up to 2 days, but
absolutely highly blessed.
So it's very. I've heard it's very effective. It doesn't take much time, and you'll get your relief quick if you're entitled to any.
Understood. No, question on principle, on a personal basis, I mean, I'll be more than happy with Justice Banerjee or Justice Rafiq. But
you'll be appearing personally also.
That will depend.
Item number 5.
After 2 days, my lord.
2 days.
Well, here I'm required to file affidavit. Sent for signature, my lord. Maybe 3 days time, my lord, we will file it.
1 week for the time has paid for affidavit by the respondent.
My lord.
6.
Much of your lordship.
My lord, it is under file, my lord.
We'll fix for hearing?
Yes, ma'am.
Parties submit that the hearings are complete. According to the matter of hearing after
convenient
Diwali, after 2 weeks.
Grateful.
Highly obliged.
7.
But here we require some time, my lord.
Please, lordship, I just want to pray just to have a look at the page number 21 by plating. There is only everything they have paid, only the gratuity which is pending, only 3,40,000, 3,40,400.
Mr.
Yes, because
which page?
The page 21, my lord. I'm the daughter of the deceased employee. My mother passed away. Now here this is the succession certificate. As per the succession certificate, all the money what's mentioned in the succession certificate, I got it. But only this is written that gratuity, that only the gratuity, only for the gratuity that is remaining 3,40,400. Only that money they are not paying.
Instructions, Mr. Bharatsaji.
My lord, I have received instructions, but my lord, some clarification is required because.
What clarification?
My lord, with regard to the father.
I mean, regarding entitlement of the writ petition.
My lord, regarding the father's
name.
Not only that, my lord. No, there is a confusion there.
Regarding?
Because the father's name is different, my lord.
But then they've already got from a competent court, they've obtained a succession certificate.
And others we got it also, lordship. It is not that we have. Yes.
What are the instructions? Father's name is different?
Yes, my lord.
But the person is the same.
No, my lord, she is actually not the. What had happened, my lord?
That means in succession matter, there's no objection from anyone else, correct? Then
that is them, lord.
Then you're bound to pay.
So they have paid.
Sometime we'll be filing.
Sometime what?
They have paid all the.
Bharatsaji today has read his prayer for filing of affidavit. He submits that there is some confusion with regard to the name of the name of the father of the petitioner. It is noted that the succession certificate granted on this 24 August 2021 is from a competent court. And should any objection,
there is no objection.
Should any objection be there, the same should have been adjudicated before the competent court which granted the succession certificate. So, Mr. Kibarchi is directed to obtain instructions or to file affidavit before the next date.
Yes.
What about you? Yes, MS Ivasa also submits the affidavit on behalf of the respondent number. Well, we file the course of the day. We file it within 2 weeks. Yes, just after 2 weeks.
Much less lordship.
Item number 8.
These gratuity and pension and all, if there shouldn't be any hiccups. If these people they need that money.
But we are required to file affidavit, my lord. This is what district council.
District Council?
GHDC, my lord.
Is the same on Hito?
Yes, my lord.
Lordship, I'm praying for 10 days to file my affidavit. My affidavit is ready. I'm just awaiting some annexures.
You've taken enough time.
Lordship, just 10 days, Lordship. My affidavit is ready. It's already prepared. I'm just waiting for some.
What is the memorandum or the objectives of your
I'll place
association?
that, Lordship. It's just a organization to look into the
Do what?
of the Hindu trip.
Is it registered?
It's registered, Lordship.
They have a list of members.
Lordship, yes. In fact, what had happened here is we had only lodged an FIR. That is all that we did, Lordship. And how this
This court is inclined to delve a little deeper into how these things work out. If on the whether there's some extraneous kind of pressure or something.
In fact, we were also
Because you can't disrupt the workings of constitutional authority.
Lordship, only thing that we did, Lordship, I'll place my affidavit that we got certain complaints that they are collecting money in that check gate or whatever. We lodged an FIR, Lordship. That is all that we did, and we were also never heard.
You should have filed it a long time ago. How many times you played the affidavit?
Twice, Lordship. I'm just praying for one final.
Yes.
I'm also yet to file affidavit.
Yes, though repeated apologies have been granted after behalf of the respondent 125, represented by Dr. Musika, and number 6 by Mr. S. Deb are yet to be on board. This after 2 weeks expected by next date. The affidavit should be filed.
Item number 9.
It's in item number 9. For the respondent MTDC. I have received my instructions. I'm praying for 2 weeks, my lord. The affidavit, the preparation is underway.
As for the 2 weeks as played, it's allowed.
Obliged.
10.
Yes.
My lord, in item number 10, my lord, affidavit in opposition has not yet filed, my lord.
I'm praying for some more time. This is a relatively new matter.
How much time?
6 weeks.
When was this matter filed?
August.
No, 3 weeks for the time it's played. Yes.
My lord, much of lordship.
11.
Please, Lordship, the respondents are yet to file the affidavits, Lordship.
My lord, I'm praying for some more time, my lord, to file the affidavit.
This is a land acquisition matter, Lordship.
Yes. For the 2 weeks time it's played. Yes.
12.
My lord, I'm entering appearance for respondent number 4, my lord.
What about 5 and 6?
5 is the principal.
Yes, Lordship, I have taken steps. Let me obtain status.
That is principal of
Principal
of the college?
Yes, Lordship.
But then, Mr. D,
my lord,
you are appearing for governing body.
Yes, yes, my lord.
What about the principal?
Principal, my lord, I have to take instruction whether they will ask me to appear for him also or not. I'll take instruction, my lord, on this. On the meantime, let my friend also find out the status report, my lord.
Yes, officer indicates that AD card, service not complete, respondents 5 and 6. Mr. Areng.
Yes, Lordship.
Please phone allowed to obtain status of service on the respondent 5 and 6. Today, Mr. SD has entered appearance on behalf of respondent 4. And please for
3 weeks, my lord.
Similar prayer with Mr. H. Abraham for 1, 2, 3. Just after 3 weeks. Yeah.
Much obliged.
13.
Your Lordship, we've received instructions, but we need 2 weeks' time, Your Lordship, to file
What's
our
the matter
affidavit.
about pension?
No, Your Lordship, this is for regularization, Your Lordship.
Yes,
Your Lordship, if they may speed up the filing of affidavit in opposition, Your Lordship, as the petitioner is on the verge of retirement, Your Lordship. You have at most 2 years, Your Lordship.
This is the first time.
Yes, Your Lordship.
Well, enough, man. Yes,
This is the first time
for the
after
2 weeks time allowed to plan the AG.
2 weeks.
And have state respondents to file affidavit. Yes.
14.
Legible.
May it please your lordship.
Yes.
Your Lordship, I've already
Number
filed my
5.
affidavit of service. I've filed, Your Lordship.
Number 4, Your Lordship.
What, number 5?
Number 5, I have filed affidavit of service, Your Lordship.
This is the.
It's a pension matter, Your Lordship.
Yes, no. Number 5, second wife.
Yes, Your
Or
Lordship.
first wife.
Second wife, Your Lordship.
You're the first wife.
Yes, Your Lordship.
Yes. Who's going for the state?
It was S. Bhattacharya, Your Lordship.
She's not here. Yes, Abraham, you're appearing. Yes, after it's not filed.
No, Your Lordship. I'm praying for some time, Your Lordship.
The office indicates that. Oh no, those affidavit filed indicating service upon is respondent by file. Whatever, there's no appearance on her behalf today. That's the H. Abraham on behalf of MSS Bhattacharya Leonard GA, correspondence 1, 2, and 3, and MS TV Pasa for 4 pray phone allowed. 2 weeks time to file.
Highly obliged, Your Lordship.
15.
Please, Your Lordship, I'm praying for 2 weeks' time.
Yes, none appears for the petitioner. What about respondent number 1? You're for? You're for number?
3 and 4, Your Lordship.
And you're for?
Your Lordship, 2. Respondent number
2 is UGC?
Yes, Your Lordship.
Yes, you're filing affidavit? No.
Will be fine, Your Lordship.
Yes, MS Islam State for number 2 and MS Ibla for from 3 and 4 pre phone allowed. Further 2 weeks time for affidavit stop. So N Muzika, he won't file affidavit. Then it counts the SGI for R1 submits that no affidavit forthcoming from this respondent. This after 2 weeks. Yes.
16.
Similar matter, Your Lordship.
Yes.
Similar matter, Your Lordship.
Yes, same order. Identical respondents.
Yes, Your Lordship. Highly obliged, Your Lordship.
17.
Lordship, we are yet to receive instructions in this. We need about 3 weeks' time, Lordship, to file
Why 3 weeks
affidavit.
time?
We have not yet received the instructions.
What's the
Your
matter
Lordship.
about?
This is for
Regularization, Your Lordship, order compliance. The Education Department.
Yes, MST Yangi submits that appraiser shall have 3 weeks time to obtain instructions that will file affidavit. Today is allowed. This of the 3 weeks.
Lordship.
Yes, Your Lordship.
17 to 20, my lord, is the same.
17 to
20.
20, till 20.
Till 20.
Yes. She's appearing for all.
Yes.
Much blessed, Lordship.
21.
May it please Your Lordship, I've just been instructed to appear on behalf of the respondent. I'll find my power in the course of the day, my lord.
Lordship,
What's the matter about?
Lordship, this is for disposing of the representation and supplying the copy of the decision on the inquiry report.
Who is this Madan Singh?
He was a sweeper of this honorable court. Your
retired?
Lordship. He retired, Your Lordship.
Retired in December 23.
23.
Okay.
Disciplinary case was against him, Your
The
Lordship.
old one, 1998.
Lordship.
It lasted for 10 years, Lordship.
Yes, Mr. S. and has ended appearance today. Only sole respondent.
Sole respondent.
Sole respondent.
Sole respondent. Such notice is complete. The praise was allowed. How much time?
2 weeks time.
To file affidavit. This thereafter.
Obliged, Lord.
Afterwards also.
Deeply obliged, Lordship.
Hearing. Item 23.
Yes, MS Panjam.
Your Lordship, I please Your Lordship. Your Lordship, as per dated 17/9, Your Lordship directed us to take this. We're allowed to take complete for the respondent, Your Lordship.
So where's the impediment?
We have taken Your Lordship steps, Your Lordship. Can you allow me to take steps,
So
Your
where's the
Lordship?
impediment application?
So we have filed, Your Lordship, just
When?
this morning, Your Lordship.
Have you received copy?
Not yet, Your Lordship.
Your Lordship, we have tried to served the copy downstairs, government office. So they said they cannot accept the copy. So we have to take steps, Your Lordship. We have filed this morning, Your Lordship.
No, you give advance copy to even impediment also. They'll take instructions.
This is the contempt, so whether they'll engage me or not.
Contempt?
Yes, Your Lordship.
Okay, yes. Sorry. I thought the normal case. Yes, MS El Panjom Blended Council Temperature submits that application to implead the necessary respondent from the personnel and unserved reforms B department has since been filed, but the same is yet to be registered.
Yes, Your Lordship.
So what to do?
So
This
allow
is
me
matter
to.
after 2 weeks.
Hello,
In the meantime, can we
For
take
further
steps,
orders.
Your Lordship?
No, let the without application, how can we impede it? Yes.
Hello, Blessed.
24. Lordship, connected matters up to
Up to
26, Your Lordship.
Up to
26. Lordship. Ali Abdul.
Hello.
27.
Yes, Lordship. Petitioner is denied his due promotion for want of ACR.
Seniority matter. Not promotion.
But the thing is that was it ever communicated?
No, not communicated, Lordship.
Then
That's not the issue, Mal. Kindly see the prayer, Mal, page 14. Direction shall not be issued directly responsible to give the petitioner seniority as per his date of enrollment.
What kind of prayer is this, Mr. Upadhyay?
Issue is seniority, not a promotion. Mal.
Yes. What kind of prayer is this?
Lordship, because his others colleague
Can
were
the court act upon this prayer, or even if your case was to give seniority as per date enrollment? Your main case is that he was not communicated the ACRs.
Your Lordship.
It was below average or average whatever. So you don't have the requisite points, correct?
Yes,
Lordship. Cases are all similar.
Lordship.
So then you are denied because you could not represent.
Yes.
Correct. Then you have to change whole prayer.
My lord, here I've just given a list of dates. Mal. Very short issue. Mal. He was appointed on 28/3/92, my lord. Then 2001 he was due for promotion, but because of ACR criteria he was not promoted. Seniority list was drawn up accordingly. Others were promoted in 2001. 2002 eventually he was promoted, my lord. Now subsequently, by directions of this honorable court, my lord, all of them were promoted to the rank of
Warrant officer.
warrant officer with effect from 10/10/97. But the seniority has to be maintained as per the seniority list, my lord. So, my lord, that is the simple issue.
Then,
so Lordship, those adverse remarks.
Now, adverse remark of 2001, my
now,
lord.
as of 2001, how can you present against them now?
Those were not communicated. Therefore, he was denied promotion.
Then he should have come at that point of time. You were
Lordship, he
denied.
was making
See,
communications.
the thing is that, look, Mr. Upadhyay, in 2001, you were found not to have met the ACR criteria, correct? Then after the departmental promotion committees had sat and they promoted your other similarly situated in service, the other person's service. Then
it was in 2014, Lordship, that he was due to for promotion to Naib Subedar Clerk.
2002 promotion,
but he was given in 2016. That promotion was given in 2016. It was
That is the next promotion to Naib Subedar.
See, first promotion is to Havildar, right?
No,
you are appointed as Lance Naik. Then you go to Havildar. Then you go to Naib Subedar.
Lordship,
then what happened was,
at this
a
stage,
lot of the flood litigation, then he redesignated as warrant officer.
Warrant officer.
From the date of entry
in the service.
And so that is a different story. But then how can you ask for seniority now when he never represented against your non-ground opponent?
He had represented himself before the authorities since 2015. That is 14. It is clear from the affidavit filed by the respondents. 14 onward.
The thing is that 2001 is where your cause of action arose. Correct. Because 2001 was the time when you were found to lack in ICR criteria. Correct. And 2001 is the date that your other similarly situated and juniors were promoted, they superseded you also. So your seniority list was fixed, the seniority was fixed as 2001. Now can we turn back the clock? What happened to the entire people who superseded you? Where have they gone? Means you'll jump over them. Can we unsettle a settled position? There are hundreds of decisions, or you can't unsettle a settled position. Simple as that.
He was due to
being due or being undue.
Lordship.
It has no relevance now.
I'll look at this aspect, Lordship. The matter may come up after a week. Because his cause of action has arisen from 2019 onward, that he had 14 onward, which
see, already seniority list, we were superseded 2001. Then now it's, and then your promotion to Naib Subedar was 2016.
16.
Then even by that time 15 years had gone.
The adverse remarks is still the authorities can communicate to him and he can make a representation to the authorities.
At this stage,
he can, and it is up to the authorities to consider or not to consider.
Mr. Pare, come on. Even on latches, yes, okay, we'll give you one more opportunity, but the tentative view of the court is that you have no case. You instruct your client. We'll perform last rites on next day. Right. Yes. On the prayer of able to him to come up with some authorities. It's up to 1 week.
28.
It's not a case of last 5 years ECR. If it's last 5 years ECR, you can understand. Then orders have been passed by this court, allowing to represent and for him re-examined and to have review DPC if necessary. That's the thing, if you upgrade it. Yes.
May it please, Lordship. Lordship, here, Lordship, the petitioners were recruited in the BSF, Lordship, as in the year 1994 as Naik electrician, Lordship.
As?
Naik electrician.
Yes.
In the engineering setup.
Yes.
And in the year 1997, that post got to be merged with the post of head constable, Lordship. In 1997. Now, since 1997 till there, Lordship, the petitioner is serving in the same post of head constable without a promotion, Lordship. Now, the case of the petitioner, Lordship, is that the next higher post in the cadre is sub-inspector, Lordship. And to get promoted to the post of sub-inspector, Lordship, they have subsequently introduced an additional qualification, Lordship, that of 3 years diploma in engineering, Lordship.
Diploma?
Diploma. 3 years diploma in engineering, Lordship. Lordship.
I have the notes, my lord. I pointed out of the dates.
No. Just rewind your submission. He was appointed as electrician.
Electrician, Lordship.
Okay. When?
The first appointment was in the year 1994, Lordship.
Okay. Now the electrician or Naik, whatever was, he said became head constable.
Head constable, Lordship.
He was serving as head constable.
Head constable, Lordship. From 1997, it got merged, means the date of appointment will be 1994 only, Lordship. From 1994 till date.
From 1994, that was changed to head constable. That means your case is that since you joined as Naik electrician or head constable, you not got any promotion till date.
Till that, Lordship.
Okay, yes. Continue. Then why?
Lordship, the promotion has been denied on the ground that the petitioners lack the requisite qualification, Lordship.
Or
What
three
qualifications do you have?
3 years, 3. I have ITI class 10 matriculation plus ITI Lordship.
Class
Certificate
10.
in ITI.
Okay.
Lordship.
At the time of your recruitment?
At the time of recruitment, Lordship.
Okay.
Lordship, I had made representation, Lordship, and the department, Lordship.
I'm so sorry, your next higher post is?
SI, Lordship.
Possible to?
Sub-inspector, Lordship.
Okay.
Initially, there was ASI also, Lordship, but then subsequently, Lordship, abolished, Lordship. SI. Lordship, that will be clear, Lordship, if Lordship kindly comes to page number 33 of the affidavit filed by the union, Lordship.
No, just come again.
Lordship.
The thing is that you don't have the qualifications.
I don't have
according to them. What is the qualification necessary for SI?
3 years
SI electrician, whatever.
Minimum 10 years is head constable, Lordship. Plus,
you have 10 years.
I have 10 years, Lordship. I am almost 30 years, Lordship. Now.
Then?
Plus 3 years diploma in electrical engineering, Lordship.
You don't have that?
I don't have that, Lordship.
Then?
Lordship. Now, Lordship, what has happened is that I had, with prior permission of the department, pursued a course, Lordship. Obviously in a distance mode, Lordship, but I had gone personally to appear for the examination. And I have submitted my certificate also, Lordship, which I have annexed here.
What certificate is that?
The 3 years diploma, Lordship, in engineering, Lordship.
So you have that now?
I have that now.
When did you obtain that certificate?
Lordship, in the year, Lordship,
June 2012.
2012, Lordship.
June 2012?
Lordship.
Okay.
But the department is not considering this on the ground that this
Where's
is...
the affidavit you say?
Lordship, affidavit filed by the union, Lordship, page number 33.
Page number 33?
33, Lordship.
Yes.
On the left hand side, Lordship, number 1, junior engineering engineer electrical junior grade / sub inspector, Lordship.
Junior 25. What's 25? 25 means?
Junior engineering electrical junior grade.
At the column 2, what 25 is star mark, what does it mean?
Lordship, that could be, I think, the serial number, Lordship, whatever. Vacancy, maybe, Lordship. Vacancies.
25 subject?
To variation dependent on workload. Generals, column number 7, Lordship, will kindly see, Lordship. Age is given there. And the next column.
Yes.
3 years diploma in electrical engineering from an institute recognized by central or state government. Or whatever physical standards have been given, Lordship. And in the column number 10 down below, Lordship.
Where's the promotion part?
Lordship, I am coming to that, Lordship. Just the column below, Lordship. 60% by direct recruitment, 40% by deputation / absorption, failing which by direct recruitment. If there are no candidates available, then those posts will be filled by direct recruitment, Lordship. Okay. In column number 12, Lordship, will kindly see. In the column serial number 2, Lordship, serving BSc personnel in the rank of head constable, having 3 years diploma in electrical engineering with 5 years service in the rank of head constable. Is 5 years, Lordship.
So you qualify there?
I qualify, Lordship.
Yes. Yes.
Lordship, now, this morning only, Lordship, I have received one instruction, Lordship, that similarly placed employees who have joined much later, Lordship, in 2014 have been given promotion, Lordship.
The electricians only?
Electrician, Lordship. May I submit, Lordship?
Have you given a copy to Dr.
I'll give you. For your Lordship convenience, I have highlighted that part, Lordship. It's a wireless message, Lordship. I'll DPC for Lordship, yes, they have given it to in the post of ASI, Lordship.
Yes. This is where? This is in which BSF from where?
This is, Lordship, from Kadamtala. 2C VSF Kadamtala Tekanpur. Kadamtala is in Kadamtala is Siliguri, Lordship. Siliguri. So they have been granted. They had.
What's the reason for them denying your promotion?
Lordship, I may also add, Lordship. These people, those 2 people who have been named here, they are holding the same qualification as they were having at the time of joining. They do not have 3 years diploma, Lordship. Now, Lordship, my case was, Lordship, that
Why have they rejected? Where's the rejection?
Lordship, in my case, Lordship,
Lordship, I was also coming to one letter which is served to me by the department, Lordship, which is placed at page number 30, Lordship, with my repetition. The type copy would be in the subsequent page, Lordship, 32.
Page 30.
30, Lordship, and type copy would be 32, Lordship.
DG store to Jammu.
Lordship. Director General Border Security Force. DG had made a tour to Jammu, Lordship, and therein, Lordship, the petitioner had raised grievances with regard to his promotion, Lordship. And in that specific regard, Lordship, they have replied, Lordship.
Where?
May I read, Lordship? Kindly refer to your UO number so and so, receipt number wide section UO dated so and so, dated 17/8/2012. It is submitted that number so and so, Head Constable Electrician Devaki Nandan Yadav, that is the petitioner, Lordship, of Frontier Headquarters Jammu, appeared before Director General BSF during Sainik Sammelan held on 3/8/2012 and raised the following grievances. Number one was non-getting promotion in engineering setup even after rendering 10 years of service like MT technical personals. MT technical personnels were getting promotion, Lordship. Drawing less pay from his juniors. This is one of the another of his grievances, Lordship. In this context, the following is submitted. This is the reply, Lordship. Number so and so, Devaki Nandan Yadav was appointed in BSF on 26/1994 as Naik electrician and further promoted to the rank of Head Constable Electrician on 10/10/1997. No promotion avenues were existed for Head Constable Technical of Engineering setup in the Recruitment Rule 1999, Lordship. Resultantly, no seniority list of others technical of engineering setup was made. Column number C, serial number C, Lordship. Now, Recruitment Rule 2012, Engineering/Electrical Group B post has been notified on 10/10/2012 by GSR 10, in which promotion avenues, that is 40% of post of SI/Junior Engineering Electrician, is to be filled by promotion of BSF Head Constable, Wireman, Lineman, Electrician, Lordship, Electrical Generator Operator or General Mechanical having 3 years diploma in Electrical Engineering with 10 years regular service in Engineering Setup / PAP, I think it stands for Punjab Action Plan, Lordship. With regard to existing Recruitment Rules 2012, Engineering/Electrical Group B post, tentative seniority list of all ORS, other technical engineering setup, including Head Constable Electrician, has been prepared and circulated to all concerned Frontiers Headquarters, Lordship, for verification of their particulars from service records, wide letter number so and so, Lordship, dated 21/8/2012. Next serial number is important, Lordship. On finalization of seniority list, promotion process for eligible ORS technical will be initiated immediately, Lordship, for which all Frontier Headquarters have been instructed to keep ready records of affected personnel for promotion wide signal number so and so, dated 5/9/2012, Lordship. So here they are saying that all aggrieved personnel who have not got, they will be granted promotion, Lordship. But after that also they have not acted on this letter, Lordship. This is 5 September 2012, Lordship. Way back, Lordship.
No, where have they rejected saying that you don't qualify? That's what
Lordship,
your personal rejection. Where is saying that are they questioning your diploma?
They are, Lordship. Yeah.
Where is that?
In the affidavit they have filed, Lordship.
No, show the rejection from your petition.
Lordship, I'll come to that. Lordship, I do not have a rejection on written, Lordship, but in the affidavit filed by them, Lordship, Union, they have
Whatever
rejected,
it is,
Lordship.
wait,
Lordship, I can do that.
let's see your prayer. Because you said that issue directions to respond consider British diploma as valid. Now they have to. There's the letter showing that they don't recognize it. Where's the letter?
Lordship, they have enclosed
Just
that,
show
Lordship.
that letter.
Lordship, page number 3, Lordship, of the affidavit filed with the Union, Lordship.
Then how do you file a petition when you were not aware of?
Lordship, verbally they have rejected, or since then they have been rejecting, Lordship, on the ground that they do not have, petitioners do not have valid required qualification, Lordship.
Page 3.
Page 3, Lordship.
Yes.
Lordship, serial number E.
E.
As such, the diploma which the petitioner possesses is of distance mode and is invalid in accordance to norms of AICTE, Lordship.
So where's the,
Lordship,
where's the
Lordship,
letter? It must be on the basis of some letter or some order that they don't recognize this AICTE. Invalid in accordance. Where's the norms?
Lordship.
I prepared the matter today.
Lordship, I am a little handicapped, Lordship. I'll see. Lordship, that letter I got, Lordship, on which page number 43.
You can't have stop and start.
Lordship, page number 43, Lordship.
Of your petition?
Of the affidavit they have filed, Lordship. The public notice, I think this is the basis on which they have de-recognized the.
Read it, what is this?
Lordship, public notice as per the Government of India Gazette notification number so and so dated 1995 issued by the Ministry of Human Resource Development. The qualifications required by the individuals through distance education mode are recognized for the purpose of employment to post and services under the central government, provided these have been approved by the Distance Education Councils, Indira Gandhi National Open University in New Delhi, and wherever necessary by All India Council for Technical Education, New Delhi. The technical education program which fall under the purview of AICTE are in the fields of engineering, technology, including MCA, architecture, town planning, management, pharmacy, hotel management, and catering technology, applied arts and crafts, and such other programs and areas as notified by the council from time to time, with the approval of the government. It has been the policy of the AICTE not to recognize the qualifications acquired through distance education mode at diploma, bachelor's, and master's level in the field of engineering technology, Lordship. Lordship, this is the notification based on which the union department is rejecting petitioner's qualifications.
All existing student prospective students. Then what will happen to distance education thing then?
Lordship,
diploma, bachelor's, master's level engineering technology, diploma. That means
diploma in engineering, Lordship. Master's level in the field of engineering technology.
So your diploma in
engineering, Lordship. 3 years diploma in engineering, Lordship.
Yes.
Now, Lordship, even if I am promoted to the post of sub inspector, Lordship, I will be required to work in the same setup, Lordship, which I am already working. So since the last 30 years, Lordship, I am quite abreast with the function.
But that's the issue, Lord.
But then the other criteria allows if you work in the same field, correct?
Yes, Lordship.
For consideration, yes. So your ground is that is not recognized, so you can't promote him. Is that the only case? Is that the only case, rather?
Yes, my lord.
What is this?
Well, Lordship kindly comes to my affidavit, my lord.
Yes.
Case 43, will start from there, my lord. Mr. Pandit read out this is a public notice by AICTE.
Yes.
Now, second paragraph, it has been the policy of the AICTE not to recognize the qualification acquired through distance education mode at diploma, bachelor's or master level in the fields of engineering, technology, architecture, town planning, pharmacy and hotel management and catering technology, applied arts and crafts and postgraduate programs in management. So these have been excluded from online mode, my lord. Other degrees are valid. So that's first thing, my lord. Second thing, page.
Okay, notwithstanding this diploma aspect, What about the other criteria given that he's been working in this field only?
Well, the criteria, this is a specific requirement, my lord. If I may just take lordship to recruitment rules at page 36 of my affidavit, my lord.
Affidavit?
Yes, ma'am.
Yes. What can they be left on the avenue for promotion? Have you got ACPs
Yes, my lord. Lordship.
and financial upgradation?
Yes, Lordship, that I have received, Lordship. I have made a prayer with regards to that also, Lordship. I will come to that subsequently, Lordship. But another aspect, Lordship, is that they've already, this recruitment rule was amended. The 3 years criteria was brought in much later, subsequent to the petitioner's enrollment.
Okay,
Lordship.
Continue. What do you want to show? Page 36.
One second. It's 36.
Page 40.
60-40. But I'll come back to that, my lord. Thereafter, my lord. Page 59, my lord. Page 49.
Page
49. So these are communication. My lord, 51 is more relevant, my lord. Page 51. This is order by BSF that distance diploma will not be recognized by BSF.
Where is that? Page
51, my lord. This is order by BSF. Para 2, my lord. Whereas recruitment rule 99 were superseded by revised recruitment rules. Therein first time the provision of promotion to the said post of sub-inspector from the feeder grade has been introduced as under border security post, engineer electrical group B post 60-40 by direct and promotion, my lord. For promotion.
Where are you reading from?
Page 51, my lord, of my affidavit.
Okay, whereas the department had appointed eligible personnel, so, whereas recruitment rules and procedures were 2012, for the first time, promotion to post sub-inspector line have been introduced. Okay.
60-40 promotion and direct recruitment, my lord. Then it says, serving BSF head constable, having 3 years diploma in electrical engineering from an institute recognized by the central and state government, with 10 years regular service in engineering setup, PAP.
He comes under this definition.
But the only difficulty is with the diploma, my lord. His diploma is online, my lord, and online is not recognized.
Lordship, if I may submit, Lordship, kindly.
No, my lord, I'll just
finish.
On page 56, Lordship, kindly come. Page 56. Now that university from where he obtained the degree, my lord, even that university has been directed to be shut down, my lord. Page 56.
Shut down?
Yes, my lord. Page 56, para 1, my lord, at the bottom. Report of fact-finding committee.
Yes.
EILM University 8th Mile, Budang, West Sikkim was not authorized to open study centers off-campus centers beyond the territorial jurisdiction as per the judgment of the Honorable Supreme Court of India in case of Professor Yes Pal and so and so. Now para 3, my lord, on the next page. State Government of Sikkim has accorded approval for the resolution of the EILM University in its cabinet meeting held on 28th April 2015. Say something like CMJ University, my lord.
That means you don't have to, of course, just purchase the degree.
Lordship, with respectful Lordship, this notification of order by the BSF is dated 2014, Lordship. This is subsequent to my diploma, Lordship. I obtained diploma in the year 2012. Clearly, see petitioners and other similarly situated. Personnel will be.
Consideration is fine. Now they've reconsidered.
Lordship.
They're not eligible, so.
But there are a few more documents, my lord.
Yes.
There are some more documents, my lord. Page
Yes.
59.
Let him finish. Yes.
Sure.
Page 59, my lord.
Yes.
This is the University Grants Commission Open and Distance Learning Program and Online Programs Regulation 2020. Now at page 61, Lordship, kindly see subpara Z, my lord.
Yes.
Prohibited programs means such programs which shall not be permitted to be offered in open and distance learning mode and online mode in higher education is detailed under the programs in the disciplines including their allied domains of engineering, medical, physiotherapy and so on. So engineering is prohibited online, my lord. Now page 63, my lord, is another circular by AICTE. In fact, in my note, I've mentioned all the points. Page 63 is a circular by AICTE. Second paragraph, in this regard, it is informed that it has been the policy of AICTE not to recognize the qualification required through distance mode at diploma, bachelor's and master's level in the field of engineering, technology, architecture, town planning, so on. So engineering is prohibited, my lord.
Okay, without, suppose you don't consider the diploma, is he eligible for promotion?
He is not, my lord.
He's been working in the field. Considering he's been appointed since 1994.
My lord, only the length of service is...
Because length of service in 94 has been appointed and he does no avenue for promotion. 2012, according to his submission, the rules have been brought in whereby the avenue for promotion. But the thing is that he'll rot in the same, stagnate in the same post till the end of his career.
But my lord, financially he is not suffering, my lord. He has been granted first SCP and second SCP. I've mentioned in this, my lord, or he has been granted on 2006 first SCP, 2014 he was granted second MSCP. So as and when he's due, he'll get his third MSCP.
Lordship, Mr. Pandey, what to do?
Lordship,
how to bury your case now?
No, Lordship. Lordship, my humble, respectful submission, Lordship, is that there is not a case wherein the higher post in the cadre doesn't exist, Lordship.
If you're claiming your claims for promotion based on the diploma that you've obtained, that diploma, even the court cannot grant any
Lordship,
even any credibility to
Lordship, I concede that even if my diploma is not considered, Lordship.
Yes.
Similarly situated personal, Lordship. I just
that hasn't come on affidavit. How
Lordship, I'll bring it on.
That we don't know whether that is through regular course or through distance.
That is what.
Lordship, no, they Lordship, I'll bring it on affidavit, Lordship.
It cannot be deholds the rules.
Lordship.
Or the criteria.
Lordship.
That means they've gone above the criteria prescribed in those rules of promotion. Then, if they've granted promotion to those similar situated people who you submit do not have the diploma requisite qualifications, you want to will close the matter or you want to?
No, Lordship. Lordship,
you have to fight another day. That's what they say.
Lordship, another submission, Lordship, is that another aspect of the matter, Lordship. This requirement of 3 years diploma was brought in much later, Lordship. After I joined the service in 1994, this recruitment rule was amended and that criteria was brought in only in the year 2012, Lordship. Much later, Lordship. Around 15 years later, Lordship. At the time of my entry, Lordship.
At the time when you enter of service, you enter the eyes wide open that there is no promotional avenues. Finished.
No.
Right? There were no promotional avenues given anywhere by executive orders or by nothing. You entered as Patrician Knight, that is okay. That's it. But then after 2012 came, then they opened up the avenue for promotion to become sub-inspector. Then they put in the conditions. So it's understood that you have to fulfill those conditions.
Lordship, in that case, Lordship, allow the petitioners to go and allow to go and pursue a regular course, Lordship. That also
is court allow that now. So go and pursue.
The department, Lordship,
we have made
it 55 years now,
Lordship. Lordship, promotion, the higher post in the higher cadre exists, Lordship.
See, we'll do one thing. If you want to put on an affidavit and try to substantiate, yes, then maybe just for consideration.
Lordship.
But otherwise,
in other cadres, Lordship, only in electrician cadre, engineering setup that is not allowed. In other setups, Lordship, promotions are being granted.
So what is the court going to do?
Lordship,
is it discrimination?
Lordship, the department is in that
expectation. You make up your mind. Should you dispose it off or you want to file this on?
Lordship, I'll bring it on record. This
when you get the details,
Lordship.
Though hearing is substantially completed, Mr. S. Pandey has produced a WT communication dated
This was the date here. 9th October 25.
9th October 2025, wherein he submits similarly situated head constable stroke electrician have been granted promotion to the post of sub-inspector, even though do not possess a diploma in engineering stuff. He prays allowed to bring the same on record by way of affidavit along with connected relevant materials in support of this contention. It's up to 2 weeks.
The next matter is identical also.
Yes.
Item 29 is identical also. Deeply opposed.
But if you are applied strictly, then
31.
Wait.
May it please, Lordship. Lordship, my apologies for the earlier mistake in the mentioned list. As there is a mistake.
It's all right. You have to apologize to yourself. Remember that you have to know, especially you're a junior, and you're very sure because you're standing for the court, and because once you know that the High Court is a court of record.
Yes, sir.
So you make wrong submissions recorded, what will happen?
My apologies, Your Lordship.
No, it's all right. No need to apologize. You only have to be careful. Always be careful. Because sometimes the seniors just don't tell you, sir, go and mention this, right? You don't even know what the case is about. In your case, you don't even know what his number was also. So this shouldn't happen, that's all.
Yes.
Yes, why you don't want to do the matter?
Lordship, we are not ready for the matter, so I prayed for 2 weeks' time, Your Lordship.
No objection.
Not ready for the matter. You're ready for the matter.
Actually, my salary is being impinged by this interim order, Lordship. So, because I am serving in the chair, I'm sitting in the chair.
Impinge the sense in which way?
Lordship,
have you been given promotion orders?
Lordship, I was promoted. I'm the promotee.
But the orders operating from this court?
Yes,
interim.
because of the interim order.
Then unless they're ready to finish the matter, then we can't. Whatever dues you'll get, you're getting a salary.
I'm getting my salary. Not as per the post. Lordship.
Yes, when do you want it?
After 2 weeks, Your
Tomorrow?
Lordship. After 2 weeks, Your Lordship.
Yes, MS Idakar, we have prayed that the matter be adjourned for 2 weeks due to personal difficulty of her senior arguing counsel. Stop. Seems objected to by the petitioner and conclusion thereof is after 2 weeks.
Interim order may continue, Your Lordship. Lordship, interim order.
Obliged, Your Lordship.
32.
May it please, Your Lordship. My Lord, the contentious issue here, my Lord, that's briefly I'm saying. Contentious issue is here, my Lord. I am presently holding the post of Joint Chief Academic Officer. Joint Chief Academic Officer in MBOS. Now, my Lord, there is a set of rules, my Lord, which provided, my Lord, the strength of service, hierarchy, promotional avenues. Now, my Lord, my next promotion would be, my Lord, in the post of. Give me that synopsis. My next promotion due, my Lord, is in the post of Chief Academic Officer. Chief Academic Officer.
1 second.
My Lord.
So it's not against new. Okay. No, I saw this doctor. I was thinking maybe new, not involved with you, right? Okay, yes.
No, my Lord, in the post of Chief Academic Officer. No, as per the rules, it provides, my Lord, this is to be filled up by way of promotion.
Chief Academic Officer.
Chief Academic Officer. It will be filled up by the Joint Chief Academic Officer, the feeder post. Now, what happened, Your Lordships? Last year, my Lord, August, what happened, my Lord, when I was about to enter the zone of consideration, and I was made the in charge of Chief Academic Officer, because that post was vacant. And I was about to enter the zone of considerations. I was 2 weeks short. What happened, an order was issued, which I have challenged. They brought the private respondent on deputation, citing a provision of law, my Lord, which never permits, my Lord.
So you mean you parachuted someone else?
Exactly, just to block me. Now it's more than a year. Now, my Lord, brought somebody else, Your Lordships, on deputation. Rules does not permit deputation, and they have cited a provision, my Lord. I'll go into it. Clearly, my lord, this is totally, my lord, wrongly quoted that provisions. And my promotion has been blocked. Now, my lord, if I can start, my lord, little details.
Who have they brought in? Who's representing the private
Government. This is the order of the government.
No, who's private respondent? Who's here?
Emboss.
Yeah, appearing.
Government.
You ready with the matter today?
My lord, only thing on the last occasion also, I will lodge, we will look into it. 6 adjournment has been sought.
And last time, did you take up the matter? You were missing?
No, my lord, I was in the other court. Now, my lord, what happened, your lordship? More than 1 year, my lord, my promotion has been blocked.
Okay, no, but
that is, this is a sense of urgency.
You're ready?
Yes, your lordship.
No, you're for?
For respondent number 8, 9, 10.
8, 9, 10 whom?
It is Emboss.
Emboss, your lordship.
Then who's appearing for the?
Or
state
respondents, your lordship, 1 to 7 and 11.
Okay, and who's for the
Private
respondent who's been promoted? You ready with the matter? Why? You're the one who's been appointed as chief academic, what?
Chief academic officer.
What is your name? Associate Professor. You start, then we'll make it. Tomorrow you'll be ready. Who's leading you in the case? You're doing the case yourself. Why are you not ready?
We can start, your lordship.
You start.
I start, my lord.
You start, and then we'll
can. My learned friend can hear, my lord, what are my contentions, and then he can.
He's just a beneficiary, so let the impose will be
yes.
whoever.
Yes.
You just
no,
take
my lord
notes
is
and we prepare.
my lord is away, your lordship. We'll give the court that synopsis. Oh, you can give after. My lord, the emboss has been set up by an act, my lord. That is called Meghalaya Board of School Education Act, 1973, your lordships. Now, my lord, if I can take my lord to now, my lord, pursuant to the power delegated, my lord, under the Meghalaya School Education Act, my lord, rule has been framed, my lordships, and that rule, my lord, governed the service condition, my lord. It provided what are the composition of service. Now, if I can take, my lord, to page 9 of my writ petition, my lord.
Have you made list of dates?
I have made, my lord. I'll supply it, your lordship.
So it would be easier, yes. Yes. Page?
Page 9.
Are we petition?
My law of my writ petition. The Meghalaya Board of School Education Employees, it is called, my lord, Supplementary Service Regulation 2016 provides constitution and composition of service, my lord. Now, my lord, that is Regulation 4. Constitution and composition of service. The Meghalaya Board of School Education Service shall consist of the categories of employee. A, my lord, higher, that is in the top of the hierarchy. Higher Administrative Board, Executive Chairman, Principal Director. Now, my lord, B. Below this comes, my lord, B. This is Director Administrations, Director Regional, Director Accreditation, Controller of Chief Academic Officer. Now 5, my lord, Chief Accounts Officer. Now comes C, my lord, Senior Grade 1. Joint Director Administration, Joint Controller of Examination, Joint Chief Academic Officer, Joint Chief. Now I am presently holding this post, my lord, Joint Academic Officer. Now, my lord, thereafter comes, my lord,
Joint Chief Academic Officer.
Yes.
Okay.
Now, my lord, below that comes, my lord, Senior Grade 2, Deputy Director Administration, Deputy Director, this, my lord, not relevant, Deputy Chief Academic Officer. And then, my lord, the entry level, my lord, Junior Grade, that is Academic Officer.
Yes.
Now, my lord, so far I am concerned, my lord, lordship can have this list of dates. On 13th November, my lord,
will help. No, just give list of dates.
2007.
Sequence.
Yes. 13th September 2007, your lordships. I joined MBUs as academic officer science stream on being appointed, my lord, following regular on my lord 13th September. Lordship will kindly come to page 2 of my synopsis in the bottom. 13th September, okay, my lord, 2007. I entered the service of the MBUs as academic officer science following due process of recruitment.
Yes.
Now, my lord, thereafter, your lordships, in the year, my lord, 2nd August 2017, your lordship, I was promoted to the post of my lord, Deputy Chief Academic Officer.
Yes.
Madam. My lord, that order, my lord, I have annexed, your lordships, at page 166. Promotion order, my lord. Page 166.
Yes.
My lord, 166. My lord. The type copy is at the next page 167.
Yes, okay.
These are not disputed. Even then, my lord, I have annexed all the documents. I have been promoted to the post of, my lord, Deputy Chief Academic Officer, your lordships. Thereafter, my lord, I was further promoted, your lordships. I was further promoted, my lord, to the post of, my lord, Joint Chief Academic Officer by an order dated 19 June 2023, my lord, at page 172. Page 172. In the interest of the public and the board, and for the smooth functioning of the humanity such and such, Joint Chief Academic Officer is hereby allowed to function as the Chief Academic Officer. My lord, I am sorry, my lord, that is 169. 169, my lord.
Promoted to
169, my lord. Type copy is at 170. That is dated, my lord, 5th April 23, my lord. Lordship will see at serial number, my lord, writ petitioner, designation, my lord, I have been promoted as Joint Chief Academic Officer. So these are not disputed anywhere, even then I am pointing out, your lordship. So, my lord, it is a fact, my lord, that April 23, my lord, I was promoted to the post of Joint Chief Academic Officer. Now, my next promotion, obviously, my lord, Chief Academic Officer. Now, how it is provided in the rule, your lordships. I have relevant part, I have quoted, my lord. If your lordship kindly come, my lord, page 13, my lord, paragraph 7. That is, my lord, Rule 6 of Supplementary Service Regulation, my lord, 2016. That is, my lord, entire crux of the issue is here, your lordship. Where is this? Para 7, my lord, page 13. Method of recruitment appointment.
Yes.
Selection grade. The officers of the board in categories A and B, my lord. Categories A and B of Supplementary Service Regulation 4.1 shall be made by the government. Those appointments are made by the government, my lord. The appointment to the post or post other than category A and comprising in the selection grade shall be made by promotion from amongst the member of senior grade 1 of the respective cadre. I am, my lord, now holding the post of, my lord, Joint Chief Academic Officer in senior grade 1. Now it is very categorical. Senior grade 1 respective cadres who have rendered not less than 4 years of continuous and satisfactory service in the grade on the first day of the year in which the selection is made and elected in the select list approved under such and such, such and such. Now it requires, my lord, admittedly 4 years. Now I was promoted to the senior grade in the year 23, your lordships. 23, my lords. Now, my lord, admittedly, my lord, going by, my lord, the substantive part, my lord, part 1 of the regulation, your lordships, I had not completed 4 years. But lordship will kindly come to the proviso. Provided that if sufficient number of officers who have rendered not less than 4 years of service in senior grade as specified in clause C of SSR are not available for filling up the post vacancies in selection grade as specified in clause B of SSR 4.1, appointment will also be made by promotion from amongst the officer of senior grade 1 as specified in clause C SSR 4.1 who have rendered not less than 7 years of service in senior grade 1 and senior grade 2 counted together. Now, my lords, my promotion in senior grade 2, 17. Now, if your lordship take into consideration my combined service, obviously I had not completed, my lord, 4 years. But my combined service, my lord, is more than 7 years. And I had completed it, my lord, 7 years, my lord, in the month of August 2024. Last year, your lordships. Now, the post had permanently fallen vacant, and the post was vacant.
Proviso,
your lordship.
Allows you to be considered.
Allows to be considered. Taking into consideration of my combined length of service, senior grade 1 and senior grade 2.
Okay, 1 second.
Which I had completed, my lord, in August 2024.
2 plus senior grade 1.
Yes.
1, 7 years.
Now, my lord, the next provision, my lord, confusion started from here, the next provision. Provided further that government shall weigh, consider necessary and appropriate, appoint person, officer other than officer comprising in the selection grade officer specified in clause B SSR 4.1. My lord, entire confusion started from here. Now here this provision categorically say, my lord, government may not promote those people, my lord, holding the position of in the selection grade, my lord, that is clause B of SSR 4.1. Instead of, my lord, considering them from promotion, my lord, they can bring somebody else. They can make normally what happened, my lord, and the top of the pyramid, my lord, normally your lordships, the government, my lord, brings on deputation or otherwise, my lord, the bureaucrats and others. Now, this is meant for your lordships, because these will be very important, my lord. This is your lordship meant for, my lord, higher administrative grade. Higher administrative grade, that is, my lord, the executive chairman and the principal director.
Now, the government shall weigh, consider necessary and appropriate, appoint person / officer, other than officers comprising section grade officers.
Lordship.
So that means even without considering you, they can put in someone
No, not me. Here is the confusion. Well, if I can satisfy, I think, my lord, substantial part of my what I want to convey will be over.
No, but then it gives them a escape hatch.
Exactly.
That, yes, I mean,
exactly. Now, yes.
Unless you don't have to appoint you.
They can. I'm not denying it. Lordship will kindly come to page 9, my lord, to understand it again. Page 9 of the writ petition.
We're going backwards.
Yes, my lord. Now, just to appreciate this fact, my lord, it's very important. Now, what they said, officer from selection grade B. Now, what are the selection grade B here, your lordship will see? Chief Academic Officer. They may not be taken into consideration for the purpose of promotion to Executive Chairman, Principal Director. Those officers in selection grade B, they may not be considered. Government may appoint somebody else. Fine, my lord, it's not affecting me because I am yet to be promoted as Chief Academic Officer. My stake, my claim is now, my promotion is now due for Chief Academic Officer.
So you're saying this proviso will not apply to you?
No, my lord.
You're saying if like, just see, provided for the government shall
where concerned necessary appoint officer other than the officer compliance selection grade
B.
Officers.
B.
Third clause B.
B.
So clause B is just director, regional administration, director accreditation,
Chief
academic officer, and chief accounts officer.
I am not chief academic officer.
This
chief academic officer can be left out. He may not be considered for promotion where? Higher administrative grade.
Yes.
Government may, my lord, for higher administrative grade, my lord, these
So
B officers in the B may not be considered.
You won't fall as exception because this exception is only for to the high
B to A.
yes,
B to A. And here they made the blunder. Here what they did, my lord, this post was vacant for quite some time. For 1 year I was given charge. Obviously because I was not within the zone of consideration. I have annexed that document. I was given the in charge. And my lord, just before August 24, I was just 2 weeks short of entering the zone of consideration. What they did, my lord, they issued the impugned order. And Lordship will see they have relied on this provision.
Where's the impugned order?
I am not coming.
Dated?
My lord, I am coming just a second. Notification 176, my lord. Page 176. My lord, if I can read it.
Next 11.
Yes, Annex 11. 24 July 24. In pursuance to the provision below, Rule 6, Clause 1 of the Supplementary Service Regulation Meghalaya Board of 2016, and in the interest of service, Dr. Such and Such, Associate Professor, District Institute of Education and Training, DIET, Rezubelpara, is transferred on deputation and posted as Chief Academic Officer in Meghalaya Board of School Education, Tura, in his own scale pay with effect from the date of taking over charge until further orders.
We challenge a deputation only.
Deputation, my lord, no. First thing your lordship will look into it. What happened? This, my lord, as I have pointed out, provision of 6 clause 1 of the supplementary regulation do not authorize the government, my lord, except for higher administrative grade. Do not authorize the government, my lord, to resort to deputations. Because I will refer to those decisions, my lord. If the rules provides for, my lord, provides that deputation is a method of recruitment, that is fine. Unless I challenge that, my lord, they can do it. Now here, my lord, deputation nowhere, my lord, for grade B. Chief Academic Officer is in grade B, your lordships. Sorry, my lord. In grade 1 B, your lordships. Now grade 1 B, my lord, deputation is not provided. What is provided in proviso to Rule 6? That administrative officers, that means, my lord, A, can be filled up by the government, ignoring the case of the officers in B. Now here what they did on deputation, taking shelter, my lord, wrongly under Rule 6, they are saying Rule 6 is authorizing us to even fill up the post on deputation of academic officer, my lord, by deputations. Now these rules do not permit them. These rules permit them perhaps for deputation, my lord, only in the higher administrative grade, that is, my lord, higher administrative grade, namely, my lord, executive chairman and principal director. Only for those posts government has the choice. They can ignore the claim, my lord, of promotion of those cadres mentioned in selection grade B. Now the impugned order, my lord, interestingly, impugned orders say we are filling up grade B because we are authorized. We are authorized by Regulation 6. That is patently wrong, my lord. It clearly does not authorize them to fill up this post by deputation. That is very clear and categorical. There is no ambiguity, no confusion. Only the higher administrative gate, my lord, they can ignore and they can breed somebody else. Now this is, my lord, main challenge, my lord. On the face of it, it is wrong. Now secondly, your lordship.
Yes.
Secondly, your lordships. Now, my lord, from August 24, lordship will see other thing, the mala fide intention here, your lordship. This post was vacant for more than a year. All throughout, I was, my lord, allowed to hold. I have been made, my lord, in charge chief economic officer. Now, my lord, I have annexed that order. Lordship will come to page 172. Annexion 9, my lord. 19 June 2023. In the interest of the public of the board and for the smooth functioning of the office work smoothly, such and such, there is a writ petition. Joint Chief Academic Officer Mbos Tura is hereby allowed to function as the Chief Academic Officer of the board with immediate effect until further orders. And I continued, my lord, till the impugned order passed in July 24.
This was passed 1923.
1923.
Over a year.
Almost 1 year, Lordship. And when I was about to, I was 2 weeks short to enter that combined service of 7 years, they brought in this person, my lord. My humble submission, this is the way the thing has developed, my lord. The only intention, my lord, to block my promotion. Yes. Nothing else. Now, my lord, so far the law is concerned, your lordship. Lordship is fully aware, my lord, the number of decision, my lord. I will just cite in one decision. Now, my lord, nobody can claim promotion as a matter of right. That is not the court will give a direction. But right to be considered, my lord, time and again, my lord, right to be considered, my lord, for promotion is a fundamental right. Now, this post is vacant, my lord, for last 2 years almost. I came within the zone of consideration August 24. Now, more than 1 year, this person is blocking, my lord.
That's the entire case. The authorities.
Well, authorities.
On deputation and on.
Yes.
But the proviso clearly says that, I mean, as per your submissions, it's limited only to higher administrative grade. That's all. Correct?
My lord.
You don't have only to higher administrative.
Only for higher administrative grade. They can do it. They can ignore the claim of, my lord, those who are in the feeder post, that is at B.
This appointed by the state respondents only.
Yes, state, because they are the competent authority to do. And they have, my lord, very boldly they have said we have relied on 6. I don't know, they fail to understand or what your lordship. Only for higher administrative grade, you can ignore them. Chief Economic Officer, suppose I was the chief, they could have, my lord, they could have ignored my claim and brought somebody else. Yes. Then I understand. But my claim is now for promotion is Chief Academic Officer. There is no provision where it say, my lord, Chief Academic Officer, my lord, even by way of interim arrangement can be filled up by reputations, and they are referring to 6. So, my lord, on the face of it, it is wrong. And the other thing, my lord, so far the government is concerned, my lord, I am challenging a government's order. Now, my lord, government has consciously not filed any affidavit.
Don't file affidavit date?
No, we have not filed.
Why?
Because we did not have proper instructions, and we were under the impression that Mbos would be the main party, your lordship.
Then it will be.
Well, that amounts to, my lord, that's what I want to rely.
Mr. Sen, it becomes.
I think there is an order, your lordship, you can check.
No, we have said that we will file if necessary, your lordship.
If necessary, ultimately they have not filed.
Of course, necessary. We need to see your side of the story, how you interpreted this rule 6.1.
No, my lord, there is order, DA made a categorical submission before the court, they won't file.
Read out Rule 6, your lordship, that provides it to Rule 6. It's a matter of interpretation, your lordship. And we have interpreted that.
Yes, come affidavit that according to your interpretation says this.
Anyway, matter of law, there is an order, your lordship, I'll just point out. They have made
the send
lordship.
You see, we're not going to pass an order which
I am not saying
will be remanded back and appeal.
No.
The only thing is that we'll say that at time of hearing we need an affidavit.
No. What else? They have made a submission. They will not. My lord, if I can say, if they have said they will not file an affidavit, my lord, where is
we already said that.
My lord, they have said.
If necessary, we will file, your lordship. At that moment, it was.
What do you say in affidavit, Mr. Sangma?
Your lordship, this is purely interpretation of the rule. because promotion is subject to minimum year of 4 years, and also satisfactory.
No. Forget the port.
Yeah.
Now, whether your appointment of this respondent number 12.
12, yes.
Yes, is as per the supplementary rules or not?
Yes,
That's all.
yes, is as per the regulation, Your Lordship. Because there is a discretion of the government for appointment under this selection grade.
They are not answering respondents.
Mr. MSP Yangi Leonard so they're not the main answering respondents, and at this stage,
They are not the main answering respondent. At this stage, not affidavit forthcoming. Well, they have admitted it.
Sir, we need an affidavit.
I think, well, they have admitted it.
Now, in course of submission,
You see, once it comes to an affidavit, you know the stand.
No, they
cannot structure the stand on appeal. Remember that.
No. Lordship, only thing, my lord, they have admitted before the course, they will not file an affidavit,
At
my
this
lord.
stage.
at this stage,
My lord.
that is what we are.
No matter what other stage, your lordship. At this stage means
Stage
what?
of hearing, you want to file?
My lord, it can't be, your lordships.
It cannot be, but we are bound
Cannot
by
be, your lordship. That is wrong, my lord.
They should have alerted the court at first instance that you not file affidavit, you want to file affidavit.
No, my humble submission, your lordship, for more than a year. This is a Malafide act, my lord, just to block my promotion. Can they do it?
You file it within 1 week.
That way, Your Lordship.
My lord, the only thing, my lord, they ensure, your lordship will ensure, my lord, that they will not seek
All
time.
these hearings are becoming non-starters.
My lord, I
have not said
They should
time
not
all
have
the
made
time.
this submission at this stage. You will not file an affidavit. No, what it mean, your lordship? In what stage they would file? I have served them a copy. They know what are the contents.
They have not read the contents of the petition.
Yes, I am. They know the contents of the petition, my lord, and they have taken a conscious
And some
decision.
affidavit in reply
Impose
copies of
nobody.
affidavit in reply was submitted to me only today. in the
That's
court.
why the
Affidavit in reply.
Only today.
Affidavit in reply.
The only
just
thing is-
now I was given that.
The only thing is that that's why this court has asked whether who's the authority that accords these promotions. It's not embossed.
The state government.
Then
But the crux of the issue is
let them
that-
file. Then we'll.
But lordship, only thing, my lord, lordship
Yes,
can
but
understand
the
my
matter has
anxiety.
been heard.
Only thing, lordship will ensure, my lord, within a week it is filed. No adjournment is
Noted that the state respondents 1 to 7
1 to 7 and 11. You know.
have not filed the affidavit. Stop. A portal of the audit sheet reflects that on 7. Where's that?
7 June.
On 7.
23 7.
On 21st?
21st May.
21st May.
23 7.
On 21st May.
Is that?
21st May 21st May 2025.
Yes, Your Lordship. You may be allowed 2 weeks' time, Your Lordship.
My lord, that will be too long.
Yes,
your lordship, too
2
long.
weeks' time is sufficient.
26 May. First May.
21st May, Your Lordship.
I would file a stop. MST Yangi submits that on the earlier submits that as they were under the misconception.
The emboss was the main.
That, respondents 8 to 10 were the main respondents. No affidavit was filed before the matter was taken up for hearing. Stop. She, however, prays now that however, prays that as the substantial questions arisen, which needs a reply from state respondents, she may be allowed 2 weeks' time to file the same. So,
Sorry, Lordship.
Though this court notes its displeasure inasmuch as the matter has been already is at stage of final hearing. But however, in interest of justice, 2 weeks' time will be granted. They expected that next day the affidavit should be on board.
All right,
Much obliged.
Waste of time.
Lordship.
Second call, supplementary list item number 5.
Yeah, what submissions you want to make?
The issue is very short one, if your lordship will kindly see, because my friend has also filed now 17 more petitions of this nature from this department only.
They are being affected by the OM, because they have undergone training under the.
They are about 1500 ad hoc employed, my lord. So 1500. If your lordship will kindly see.
No, one thing, Mr. Arvind, yesterday we were not here. We had gone through the matter. I think Mr. Kalman was there.
Okay.
See, the thing is that they stand on different footing altogether. The thing is that they were going to bond, they signed, they
Yes, my lord.
or they've contributed to GPF, they've given all
Annual
trappings
increments,
of regular
annual increments.
employment with the condition that MPSC you have to interview, they will appear.
Yes, my lord. So that is
Then
what-
they have to be segregated from you.
No, see, the only submission which I have, my lord, that this kind of system, if your lordship will see, this kind of system was prevailing wherever there was training was required, we have given the training. Because your lordship has seen Supreme Court judgments also say that if they are discharging the functions, they are entitled to some scale of pay also, some benefits which we are giving to because the equal pay for equal work concept may come in. The question which falls for your lordship's consideration is this, my lord, that they have been working on ad hoc, on temporary basis against sanctioned posts without proper advertisement and proper process of recruitment, my lord. What cabinet has taken a decision which was brought to on 25th September 25. There are about 1514 such cases, my lord, where we have
Similar like them,
similar
who gone for training.
There will be some cases where there will be some less 1 week of training. Now, if I can see the training also, my lord, because training he has taken as a diploma engineer in Tamil Nadu, which was probably sponsored, etc. My lord, assuming, my lord, that training was sponsored by the state government, the question which falls for consideration, my lord, that whether that training will give him the right to seek.
Because look at the length of service.
No, so that is in all cases, my lord, post 2007, you will also will have those 10 or 12 or 15.
Length of service now he served for. See, the thing is that now the law is changing also.
No, there are recent judgments on that,
That I am aware. But the only issue which your lordship will consider, because I am not, again, the question is in all such cases, 1500 cases, then the issue will be we have to, because all of them are, with due respect to them, they are all backdoor appointee in the sense there was no advertisement, no process was followed, no roster was followed, my lord, and no rules were followed. It was a stopgap arrangement to carry out the function of the state government.
When were you appointed?
Lordship, in the second case, he served for 20 years, 2004.
In one case, I saw. So,
2004. 2004 will come before 2007.
Because 2004, so then that is a different case. Then you will be.
His appointment order is 2004, Lordship, in the second
matter. That will be
matter.
in different category. That will be. So that is what I wanted, my lord, that all these matters be clubbed together because they are challenging the policy of the government also, my lord. This policy, and then your lordship will authoritatively decide one way or the other.
We'll club it together and don't disturb the service right now.
Yes, my lordship will.
And not to advertise also, my lord, our post at least. Post
Because
occupied
you see,
was.
Have you gone through the writ petition?
Yeah, I have got 17. 2 of them I have gone through.
21 altogether.
21 total. 21 altogether.
You see, there is this.
And therefore, my lord, whatever your lordship will decide, it will have repercussions in respect of all such cases.
Yes.
It will have impact on.
I think they've challenged this
OM of page 44.
OM also.
You've challenged the OM.
Yes, OM is also. That's so. To that extent only, I am here to assist your lordship on the OM part. That
take down.
This is larger policy issue which your lordship will have to decide.
They've been declared yesterday. Yes.
My lordship will direct not to disturb our service and not to advertise our post. Because once they issue advertisement, my lord.
No, we will not. Don't advertise. The thing is that for this post, for this post, no advertisements. Only thing is that
I'm not saying.
Only thing because one department only. It's not going to cause departments.
Because they will. Others will also come.
But please put in affidavits as early as possible. So you can decide.
We will affidavit. We will put.
No, we'll pass on this.
Only thing what I was saying, my lord, let the process go on. Because process go on.
The difficulty is
the appointment will not be given because ultimately everything will come to.
Once process goes on, upon given selection list is there, other people are vested with
the result
rights,
may not
then
be-
we're opening
to
a
that extent,
Pandora's
not-
box.
Result may not be declared.
Third
because
party
what
rights
will
will be
happen,
granted.
No, we'll pass orders.
We-
Please, if you give an undertaking to the court that within 1 month we can complete this whole thing. We are here.
Hearing that we
Yes,
that
then
hearing
fine.
to
Then fine, so fine.
that we will do lots of, because in 1 month nothing is going to happen. In 1 month,
No, third party rights will be created.
No,
That is
in 1 month,
exactly. You don't
recruitment
create
has
third
taken
party
place.
rights.
No, in 1 month, no recruitment has. If my friend
We have to
said so,
implement
one
them,
recruitment in Meghalaya, in 1 month, we will file the affidavit.
Then the learned AG will come and say, we implement them as a party. My
No,
lord.
within 1 week, my lord, or my friend can.
No, we know what to do.
Within 1 week, we'll file the affidavit, my lord. Only because what is going to happen, my lord, that others will also. It's like opening of floodgate, and entire selection process will come to grinding halt.
No,
My
others
problem
won't be.
is
I don't think it'll be situated like these people. Others are just
Because this is a
appointed blindly. These people who appointed, they applied, they were selected for
This
training,
is a
they went,
policy.
they were given appointment in they got legitimate expectation
This is
to
a
be
policy.
accommodated. They signed a bond.
This is a policy. Now,
My lord, in fact, I'll cite some reason. Since 24, my lord, Justice Vikram Nath has passed 3 judgments, my lord. One is Jaggo, one is Sripal, and one is of August judgment, my lord. What Supreme Court has said that you cannot allow them to continue for 10 years, and you have done so. Even sanction post is not required. You have to create supernumerary post.
I'll
place that also.
answer these.
No, now, Lord, you see the judgment
We'll
has
answer.
changed because Uma Devi is
diluted. That
No, not diluted. Uma Devi has been clarified, my
but the
lord.
basic Article 15 has not been diluted. My question is this, my lord. Article 15 cannot be diluted.
Second
Article 15.
Item number 3, daily list.
But there are 2 matters, 5 and 6.
Both matters. We'll file within 1 week.
Yes, Mr. Pani, this is your application.
Yes, the application
Yes, that's
is
an
also
application. It's not numbered yet. Yes. Application to allow the applicant is the
Return candidate.
stroke bracket return candidate to withdraw himself from the list of respondents, witnesses at this stage. Yes. At this stage, determination of preliminary issues stopped. The same was objected to by the election council election petitioner. Accordingly, the application stands allowed, and the name of the return candidate, namely so and so, is withdrawn from the list of witnesses. So, this case allowed. And in the main case, as the evidence on preliminary issue has since is thus concluded, in view list the matter. When you want the matter, we'll have a hearing soon.
Kindly fix on 11 November, yes.
We don't want to prolong it, just short.
Yes, because before that,
one day only. You have to finish your own 1 day.
Yes, we'll try to complete it.
It's just the matter.
This time, I hope my senior will appear for our final.
Chandro, I think
Yes.
too busy. Yes. Yes, on 11 November.
Obviously.
Yes.
Please, Your Lordship, I humbly request that item 4 from the supplementary cost list be taken up on Friday, Your Lordship, not on Thursday, as the conducting council will be out of station on Thursday, Your Lordship.
The review application?
Yes,
then
Your
we'll take it
Lordship.
after Diwali then. There's no hurry.
Next week, Your Lordship, any date next week, Your Lordship.
Next week.
We oblige, Your Lordship.
Number 4.
Yes, Your Lordship, item 4. Yes, sir.
And 14. So that is all I have to submit, my lord.
Where is that judgment?
That judgment is part of the reply to the affidavit application. If you also will kindly see.
Reply to the miscase.
A miscellaneous case, my lord. That is at page 23.
Where is Mr. Goswami?
It's because he is online.
You'll make the reply. You'll make the reply.
You will.
Yes,
You will make the reply yourself.
No, Mr. Goswami.
So in paragraph, this is at page 23,
Okay.
and also at page 26 to 26, 27, my lord, 28.
Okay. Yes.
Lordship, for rejoinder, please.
Yes.
Paper copies. Paper copies and Tamil Nadu. This is Bengali. This is Tamil Nadu one.
We can close them. You want to make all arguments? Or this will suffice.
Only for only judgments so you approve side.
You just kindly give the list of
Copies of the
just give the judgment.
Copies of the judgment. Copies of the judgment.
As we already heard, Mr. Goswami, this is just this rejoinder also is just rejoinder is only just
correct.
Yes.
It's only what he has already argued.
Those, yes. My lord, as per judgments, my lord, as per petitioner, they have admitted that as a company is concerned, Companies Act, they have stated in page number 15, para 35 of the reply. My lord, whatever the Mr. Amit Kumar has told, AG also, that it is a company. My lord, it is a not sovereign company, only Company Act is applicable. My lord, in that situation, my lord, I have given the judgments, Hindustan Paper Corporation Limited versus Union of India and others. In that, my lord, para number 1 and 2 is, my lord, I will not read because I don't want to take any times, because these already it is an admitted fact that this is a company under the Company Acts, not as a sovereignty act. For example, NHI, whatever may be there, therefore it is not applicable to Meghalaya Corporation. My lord, there is also, I have mentioned in the written submission also, these are the documents which they have been provided. As per my lord, yesterday my learned AG has cited that agreement. In that agreement, I was not a party. Therefore, it is not applicable because
Tripartite agreement.
yes, My lord, only there are three parties are there. Only between the party is Rural Electrification Corporation Limited, Government of Meghalaya, and Meghalaya Power Distribution Corporation Limited. These are three parties are the agreement is concerned in 2019, and thereafter also loan agreement also in 2000. That was also there is no I am not party in that. Therefore, it is not applicable to us also. Mr. Jain.
Yes.
Mr. Goswami has joined.
Yes, Mr. Goswami. You unmute yourself. Yes. So we have seen this note. In some substance, you already argued these points earlier on. So we will examine them. Yes.
I'll just go quickly through that note, Lordship. I'll not take much time. Now, if Lordship will take my reply submissions.
Yes, yes. We already seen the first judgment, that HPC, Gauti judgment. Yeah.
Yes. So Lordship will kindly see the next judgment, that is Tamil Nadu. That is again a distribution company.
Right.
In fact,
yes.
This is same like the writ petitioner. And please kindly come to the first paragraph.
Yes.
The issue involved with the present petition is as to whether a company which is substantially owned by a government is amenable to the jurisdiction of the National Company Law Tribunal in insolvency proceedings. Though the petitioner seeks to suggest that a company which is substantially owned by the government may not be complained against or insolvency proceedings brought against it before the NCLT, there does not appear to be any exemption provided under the Companies Act 2013 or the Insolvency and Bankruptcy Code 2016 in such regard. This is the finding of the division bench.
Yes.
Then Lordship will come to para 5 of the same order.
Yes.
The petitioner, however, accepts that the second respondent has a right to approach the NCLT, but asserts that the petitioner has a right to raise legitimate disputes qua the claim. Indeed, it is the petitioner's case that the petitioner has a counterclaim and there is no net amount that can be said to be payable to the second respondent herein. It is certainly within the domain of the NCLT to adjudicate upon the dispute raised by a debtor in any insolvency proceedings brought about by a creditor. Indeed, the NCLT is obliged to decide such issues before the NCLT can arrive at a conclusion that the perceived debtor company is insolvent. Accordingly, since the petitioner seeks leave to raise all disputes pertaining to the claim of the second respondent before the NCLT, WPC so-and-so is permitted to be withdrawn with liberty to the petitioner to raise permissible disputes in accordance with law before the NCLT. Last line. However, the petitioner will not question the authority of NCLT to receive the petition.
Yeah.
That is important.
Yes.
So this is the Lordship has seen two division bench judgments. One is at Hindustan, which is the division bench judgment of the Guwahati High Court. In any case, the learned AG yesterday has accepted the fact that government companies comes within the ambit of IBC. So I don't need to, except for reiterating what I had submitted earlier, I don't need to dwell on that anymore.
Any other judgments? No. That's it.
So there are Lordships.
Yes.
Now Lordship will kindly have a look at my submission number 2.
Yes.
It may be noted that the writ petitioner has neither denied nor disputed the respondent's allegation of suppression of material facts in the writ petition. See para 1 of the writ petition. On the contrary, the averments now made in para 34 proves this allegation. It is therefore most respectfully urged that the writ petition may be dismissed in exemplary cause on this ground alone. Because today, if Lordship will see para 34 of their reply to the vacating application, please see page 15, para 34 of their reply.
Yes.
There they accept it.
Page 34. Yes.
Page 15, para 34.
Sorry. Submitted. Yes.
So they accept the position now in their reply, which they have suppressed in the writ petition.
Yes.
Now, yesterday an argument was addressed by the petitioner about being a statutory authority under the Electricity Act. I have to respond to that. But kindly come to my third submission.
Yes.
It is a fallacy to contend that the writ petition is a statutory authority under the Electricity Act 2003, inasmuch as the petitioner cannot at the same time be a company incorporated under the Companies Act 2013. It can be one, it cannot be both. Even otherwise, a perusal of section 131 and 2, read with section 2, subsection 13 and section 2, subsection 31 of the Electricity Act will make it amply clear that the writ petitioner is not a statutory authority but merely a company. Would Lordships kindly take up the Electricity Act? Because I need to address this. Yesterday, this was addressed in extenso. Please come, Lordships, to section 131 of the Electricity Act. Because it is contended that under the transfer scheme, the writ petitioner has been formed. Now I will read 131.1 and 131.2 both slowly, Lordships. We need to understand it. With effect from the date on which the transfer scheme prepared by the state government to give effect to the objects and purposes of this act is published, or such further dates as may be stipulated by the state government, hereafter in this part referred to as the effective date, any property, interest in property, rights and liabilities which immediately before the effective date belonged to the State Electricity Board, hereinafter referred to as the board, shall vest in the state government on such terms as may be agreed between the state government and the board. This is the first step. Now comes 131.2. Any property, interest in property, rights and liabilities vested in the state government under subsection 1 shall be revested by the state government in a government company or in a company or companies in accordance with the transfer scheme so published, along with such other property, interest in property, rights and liabilities of the state government as may be stipulated in such scheme on such terms and conditions as may be agreed between the state government and such company or companies, being state transmission utility or generating company or transmission license or distribution licensee, as the case may be. So here is a case where the vesting is on a company. It is not on a statutory authority.
Yes.
And please have a look at section, along with section 131.2. Please have a look at, kindly come to the definition clause, section 2, 231. Sorry, 213. Section 2, subsection 13. What does the Electricity Act define company as?
Yes.
Please come to definition clause, section 2, subsection 13.
Yes.
Lordships there?
Yes, yes.
Company means a company formed and registered under the Companies Act 1956 and includes any body corporate under the central, state or provincial acts.
Yes.
So today, the entire argument that we are a statutory authority under the Electricity Act is not correct.
Yes.
They are a company on which the state government has vested its property. And when we are talking about a company registered under the Companies Act.
Yes.
So by no stretch of imagination can they claim to be a statutory authority. In any case, they are not created under any statute. So to that extent, my argument is that is a fallacious argument which was addressed yesterday. Now 4 and 5 is very, very important, Lordships, my reply submissions. Kindly take a look at my submission number 4.
I could. Yes.
if what the petitioner has urged is to be accepted, then this honorable court has to interpret and read into section 37, 38 and 23 of the IBC code that government companies functioning as extended limb of the state are exempted from the purview of IBC 2016. This is essentially what the court has to read into the section. Such an interpretation is certainly not permissible, particularly when the language used in the statute is plain and unambiguous. What the petitioner is urging is that Lordship may read into this section that government companies or companies functioning as an extended limb of the state are exempted from the purview of IBC. Would Lordships go to that extent is the question. This is certainly not permissible because the language is very clear. I will just cite one judgment and one paragraph in respect to this. Would Lordships kindly take up State of UP versus Dr. Vijayanand Maharaj, 1962 SCC online. The leading constitution bench judgment on interpretation and when you can and when you cannot add. Would Lordships kindly come straight to para 8 of the judgment. Para 8 of the judgment, it is the constitution bench judgment, Lordships. In the middle of the paragraph, the sentence starts, the first question.
Yes.
The first question, therefore, is whether the order of Justice Mehrotra in an application under Article 226 of the Constitution was in any proceeding under the Principal Act. Obviously, a petition under Article 226 of the Constitution cannot be a proceeding under the Act. It is a proceeding under the Constitution. Now the argument. But it is said, relying upon certain passages in Maxwell of the interpretation of statutes at page 68 and in Crawford on statutory construction at page 492, that it is the duty of the judge to make such construction of a statute as shall suppress the mischief and advance the remedy. And for that purpose, the more extended meaning could be attributed to the words so as to bring all matters fairly within the scope of such a statute, even though outside the letter, if within its spirit and reason. But, now the court answers, but both Maxwell and Crawford administered a caution in resorting to such construction. Maxwell at page 68 of his book, the construction must not, of course, be strained to include cases plainly omitted from the natural meaning of the words. Crawford says the liberal construction does not justify an extension of the statute scope beyond the contemplation of the legislature. The fundamental and elementary rule of construction is that the words and phrases used by the legislature shall be given their ordinary meaning and shall be construed according to the rules of grammar. When the language is plain and unambiguous and admits of only one meaning, no question of construction of a statute arises, for the act speaks for itself. It is well recognized rule of construction that the meaning must be collected from the express intentions of the legislature. So construed, there cannot be two possible views on the interpretation of the first part of the section. So my submission is today, if 37, 38 and 323 are very clear, there is no scope of interpreting or reading into something as the petitioner would like the court to do. That would be doing violence to the language of the statute.
Yes.
Now, Lordship will come to my next written submission. Though this was not argued by the learned AG, but to put things in perspective, I am placing this. The doctrine of casus omissus in the matter of interpreting a statute do not also apply in the facts of this instant case, inasmuch as there is never any presumption that a casus omissus exists in the language employed in the statute. In this regard, it is respectfully submitted that this honorable court may kindly note that if the legislator intended not to include company/government companies functioning as an extended limb of the state from the purview of section 378 of IBC 2016, it would have specifically done so, like the legislature has done in case of financial service providers. This very crucial aspect must be duly taken note of. Now, kindly Lordship will take the IBC and kindly come to section 37.
Yes, corporate person.
Corporate persons means a company as defined in clause 20 of section 2 of the Companies Act 2013, a limited liability partnership as defined in clause N of subsection 1 of section 2 of the Limited Liability Partnership Act 2008, or any other person incorporated with limited liability under any law for the time being in force, but shall not include any financial service provider. So the legislature was very, very clear who is to be exempted. If the legislature intended to keep these companies out, it would have done so. So this has to be taken note of, Lordships. Then Lordships will kindly come to, in this context, Lordships will kindly come to section 60, subsection 5. We are relying on that also. Subsection 5 of section 60.
Yes.
I will just come, Lordships. Notwithstanding anything to the contrary contained in any other law for the time being in force, the National Company Law Tribunal shall have jurisdiction to entertain or dispose of any application or proceeding by or against the corporate debtor or corporate person. So if today you are a corporate person or a corporate debtor, NCLT would have the jurisdiction. B, any claim made by or against the corporate debtor or corporate person, including claims by or against any of its subsidiaries situated in India. So 60 subsection 5 makes it very clear that NCLT would have a jurisdiction. Now, Lordships, in this context, kindly have a look at another judgment, Mukund Devangan, on the concept of causus omissus. This is 2017-14 SCC 663. I'll like your Lordships to kindly come to para 38. This is a 3-judge bench judgment of the Supreme Court. Para 38, Lordships, at page 693 of the judgment. May I place para 38, Lordships? The words cannot be read into an act unless the clear reason for it is to be found within the four corners of the act itself. It is one of the principles of statutory interpretation that may matter which should have been seen, but has not been provided for in a statute, cannot be supplied by courts, as to do so will be legislation and not construction, as held in Hansraj Gupta so and so and so. The last line is most important. The court cannot supply causus omissus. If you omit it, it's omitted. It is for the legislature. Because you are interpreting a section, you are certainly not legislating on a section. So if you have to add something, it would partake the character of the court's legislating, which is not permissible.
Yes, next.
Next, Lordships. I'm going as quick as possible, Lordship.
No, it's fine. No problem. Yeah.
These are absolute submissions on law, because then Lordship will come to my next submission. Para 6. An argument has been advanced. An argument has been advanced that overnight the state will be enveloped in darkness if the IRP is to be appointed. This is absolutely false and has been advanced only to create avoidable sensation. In reply, it is submitted that the final directions of NCLT at para 17 of the order, which is in consonance with section 14(2), subsection 2A of the IBC, adequately protects and addresses this issue. The larger public interest has been duly taken care of by the judgment passed by NCLT. Kindly have a look at the NCLT judgment also, and kindly see how it has secured the interests of Lordship. The NCLT judgment, kindly come to para 17 of the NCLT judgment, page 42 of internal page 42. NCLT judgment, para 17.
2 million for this case. Okay, no, I got it here. Page 42. Towards the end. Yes.
May I read it, Lordships?
Yes.
Lordship, para 17.
Yes.
The supply of essential goods or services to the corporate debtor, if continuing, shall not be terminated, suspended, or interrupted during the moratorium period. And please read this along with section 14 of the IBC. Section 14 of the IBC, Lordships. This is precisely what the NCLT has done. So this unnecessary concern that tomorrow, and that too, if Lordship, I may put it in a lighter tone, nobody can expect any place to go dark just before Diwali, Lordships. The festival of lights. It's Diwali, Lordship. So that, to that extent, we are also conscious.
Yes.
Kindly have a look at section 14, subsection 2 and 2A. Because this para 17 is in consonance with this. May I just place it? Subsection 2. Lordship is there.
Yes, supply, yes.
The supply of essential goods or services to the corporate debtor as may be specified shall not be terminated or suspended or interrupted during the moratorium period. Next, where the interim resolution professional or resolution professional, as the case may be, considers the supply of goods or services critical to protect and preserve the value of the corporate debtor and manage the operations of such corporate debtor as a going concern, then the supply of goods or services shall not be terminated, suspended, or interrupted during the period of moratorium, except where such corporate debtor has not paid dues arising from such supply during the moratorium period or in such circumstances as the case may be specified. So it has properly protected, and even the IRP is in law bound by this, that he has to maintain it as a going concern.
Yes.
Now, Lordship, will come to my. So, therefore, that argument that there will be disruption, there will be darkness, this is absolutely unfounded, Lordships. The NCLT has taken care at para 17, and I have placed, Lordships, section 14, 2 and 2A, which adequately addresses this situation, this concern that this writ petitioner raised yesterday. Now, Lordships, will come back to my written submissions. 7. The petitioner is an electricity distribution company. They contend that the state, through them, is exercising sovereign functions, and hence the petitioner is not amenable under IBC, since it is an extended arm of the state. Now, this is the bedrock of their argument. Such an argument is not tenable in view of the law laid down in Hindustan construction. In this regard, it may be noted that NHPC and NTPC are two monopoly government companies involved in creating infrastructure as also generation of hydroelectricity and thermal power in the country. They are also essentially involved in implementing the various schemes and programs of the union government and operate as its extended arm. If these two companies, as the union also agrees, are amenable to IBC, one fails to understand how the petitioner can claim to be exempted on the purport doctrine of sovereign immunity.
Yes.
This is my answer. That extended limb argument, lordships. Same thing they are doing. Same power sector. If the union agrees that they are subject to IBC, the state, I am sure, cannot take another step. 8, lordships. It is reiterated that the petitioner does not perform any sovereign function as per the tests laid down by the apex court. The mere fact that there is no other private power distribution company in Meghalaya makes no difference at all. Kindly have, once again, lordship, I have already shown the judgment. I would request lordship to kindly revisit para 20 of Barmer Lorry.
Yes.
Please, lordship, to kindly come to Barmer Lorry para 20. The judgment I had handed over last time, lordships. Para 20.
Yes. Para 18 and 20.
Yeah, but I want lordships to have a look at para 20 once again. May I just place it?
Yes.
Every government function need not be sovereign. State activities are multifarious. Therefore, a scheme or a project sponsoring trading activities may well be among the state's essential functions, which contribute towards its welfare activities aimed at the benefit of its subjects. And as such, activities can also be undertaken by private persons, corporates, and companies. Thus, considering the wide ramifications, sovereign functions should be restricted to those functions which are primarily inalienable and which can be performed by the state alone. Such functions may include legislative functions, the administration of law, eminent domain, maintenance of law and order, internal and external security, grant of pardon, etc. Therefore, mere dealing in a subject by the state or the monopoly of a state in a particular field would not render an enterprise sovereign in nature. That last line, lordships.
No, marked it last time.
Yes, lordships.
Yes.
Now, lordship will come to 9, para 9 of my written submissions. The petitioner has approached this honorable court only on the premise that NCLT lacked inherent jurisdiction to adjudicate on the list. Hence, it is submitted that this honorable court may not entertain or adjudicate any issues touching upon the merits of the case as delineated below that has been raised by the petitioner in the amended writ petition, which is yet to be allowed. Like issues like debt not pertaining to petitioner and not payable by the petitioner, interpreting the various contracts, agreements of the Saubhagya scheme, etc. It is respectfully submitted that adjudication of the issues pertaining to the merits of the matter lie within the exclusive domain of NCLT in its appellate jurisdiction. So it is our submission that nothing on merits need to be looked into by the court in this round of litigation lawsuit, because it was only on jurisdiction. Number 10, lordships. The respondent is not party signatory to the tripartite agreement dated 30/11/2016, and therefore reliance on the same by the petitioner is displaced. We have not even a signatory. So therefore, in conclusion, we reiterate our written submission and pray that the writ petition may be dismissed. Now, one thing, just two things, lordships, before I conclude, lordship, I'll just take another 5 minutes. Lordship may also consider the issue that this writ petition is belated, in the sense, ideally, When the NCLT initially admitted the Section 9 application, it is then, if they had seriously thought that NCLT had no jurisdiction, they should have approached the court then, not when the entire adjudication process is over. So therefore, the writ petition is belated, and that is another ground for it to be, because now the adjudication process is over, they should have come at that stage. When Section 9 application was first admitted by NCLT. The next submission good lordship will also consider is that we are saying that the writ petition itself is an abuse. So therefore, the three-pronged test which the courts normally adopt, prima facie case, balance of convenience, and irreparable loss, the writ petitioner has not even been able to overcome the first threshold. That is whether they at all have a prima facie case for a High Court to entertain. So if they have not been able to overcome the first threshold, that they do not have a prima facie case, the other two things doesn't even arise. Here we are saying at the face of it, the writ petition is an abuse. NCLT certainly has jurisdiction. So therefore, my submissions are not only limited to vacating the stay, my submission is all encompassing that the writ petition must go. It should not be construed that my submission is only limited to vacating the stay. We are arguing on the substantive writ itself that the petitioner has not even been able to make out a prima facie case for interference by the High Court.
Yes.
This is an abuse which needs to be curtailed at the earliest. I am so grateful for your lordship's time. Very grateful. But I apologize that I could not personally calm down this time.
That's all right.
I would have.
Yes.
Now, my lord, certain.
Just give a small note.
Yes, I'll give, and I'll deal with the judgments which have been cited in rejoinder. But one thing I will say, my lord, what my friend has said, that he is arguing the matter on merit, on the dismissal of the writ petition without filing reply, my lord. Without filing. Yes, I understand. I respect your choice.
Because see, the thing is that his address, he addressed everything on fundamental and elementary issues concerning the matter.
Yes,
that it doesn't necessarily do merits also if jurisdiction is proved. That's all.
So, my lord, so what my submission is that my application for amendment we have filed, which is also for consideration, my lord. Let notice go on my application.
See, only one thing, Mr. General. If we decide this matter first, if suppose it will be maintainable, then we will consider application for amendment.
The issue is, my lord.
But as it stands now,
yes, my lord. The issue is, my lord, that I have filed a writ petition. I have shown 3 judgments on the maintainability. None of the judgments have been dealt by my learned friend, my lord.
We are not disputing that.
So if those
come there, no, Mr.
Yes, let me just finish.
I said the judgments that relied on by the General are reiterating the principle of whirlpool.
So therefore, my lord, that is one aspect of the matter. Second is, my lord, if it is maintainable, it is entertainability is the issue, my lord. Maintainability is, my friend is not questioning. Now I have shown the certain provision of, so this is a discretion to be exercised by
you. Actually, you make just give your notes. I've taken the notes.
Yes, I'll place those things, and discretion, my lord.
When will you place them? By tomorrow.
By tomorrow, I will do that.
With a copy to us, lordships.
Yes. No issue.
I will definitely be educated by the AG's notes.
No, I have got a lot of education now. That is there. And the provisions of IBC code, where date, due and payable, those have not been, and only...
See, if does not been addressed, that works to their detriment.
So that is what I want to highlight. I'll flag. Yes, I'll flag it. I'll flag
the first written submission which are passed on the...
Yes.
On the points that have been discussed, that's all.
Yes, madam.
Yes. Then applicant general pays him out to file his submissions by tomorrow.
Well, lordship may have it day after tomorrow, because their judgments, because we have got some hearing tomorrow also at 2 p.m.
Yes.
Before this one.
Yes, the following. Yes.
Interim order to continue.
Lordship is again listing the matter day after tomorrow.
No, filing of
don't list it. Sometimes you won't file a notes on submission.
Notes only.
So see, we have that. Suppose you ask them to give to the registry, or to the court officer, it doesn't come on time. So unless you list it and then then they file it when the matter is called
before
up.
the court.
Yes.
That's a practice here.
Obliged, madam.